Hi guys, it's Kathy. I hope you're doing well. I had an interesting night last night. Now, all of you nurses, it's another Tuesday for you. But this is not just another night for me. This doesn't happen. I was working and in a different section than mine, Bill was there. Not Bill Henderson, a different Bill. Bill is 80 and he has Parkinson's and con- congenitive heart something or another. Um, he's very old. He's very frail. He's very thin. So I'm way at the end of the restaurant, and I see Bill like tense up. I'm like, okay, something's wrong. I'm like, hurry up, guys, take this order. I got the drink order, and then by the time I got up to Bill, he was falling over. He did not fall out of his chair, but his whole body was like cramped up. And I grab Bill. His wife grabs Bill. We get Bill on the floor. He is not breathing at all. Um, I have his head up because he can't have his head go the whole way back. So I have his head up in the air. I'm holding onto his head. His wife is calling out to him, and a miracle happens. Hold on. So I can't get to his hands, but I have his neck and nothing. There's just nothing. So I take his wife had her hands under his head too. So I take my hands, put it on his chest because I was ready. I'm not CPR certified, but I know. And this woman comes beside me, and she touches my hands and she says, "No, wait." And then I was like, sort of annoyed for a second. I'm like, this guy's gonna die. Leave me alone. She's like, real calm, super calm. No, no, wait. I'm a nurse. Oh, like everything. As soon as she said I'm a nurse, I was like, whoa, back on the head. I had the head, and she's there, and I don't know. She didn't do anything, and he just started breathing again, and and then you can see the pulse. You could see the pulse because he was very frail. All of his veins were like very visible. Um, and she's just talking to him, and we're talking to him. I have a damp cloth. I'm like, come on, Bill, you're doing good. And she just like I don't even know what would happen if we call it the ambulance. It seemed like it took forever for them to get there because I found out later it was not an ambulance that came. It was a fire truck. It was a fire truck, but six of them came in. Yeah, they did. Yeah, they did. Bill's fine. His heart was fine before he even left us. It wasn't his heart. Um, he didn't go into ICU, so he went into a regular hospital bed. So thank you, nurses everywhere. Thank you so much. I don't even know. I don't even know what would have happened if she wasn't there. Because I was ready to do chest compressions, mouth to mouth. I was ready. I was like, oh no, not today, not today, Bill. No way. And they were very cute firefighters. Yes, they were. Yes, they were. And then not one of the other servers checked my section the whole time. I was on the floor for a while with him till the firefighters came, and nobody checked my section at all while I was down there. The band stopped. Everybody was just sort of, standing there watching poor Bill. But I'm not used to that. That's not something I'm used to. I'm used to people passing out because they're drunk. That happens all the time. I don't need a nurse to help me with that. But not this. I'm gonna go tomorrow. No, I won't. I was gonna go in and say hi to Bill, but no. He didn't want to go to the hospital. He was very ornery. I don't want to go. I don't want to go. We're glad you're talking. All right, let's go to Crazy McDonald. Yep, yep. I had Staying Alive in my head ready. I was ready. Oh yeah, poor Belle. My Belle.
And so you were charged.
Pieces of paper about the silver bullet, and his whole argument, your whole presentation today revolves around these criminal cases. And so it is absolutely relevant. You've opened the door. I think the case law and the statute support this decision clearly and unequivocally. Counsel, continue.
And so you were charged on February 8th, 2017 with another violation of an extended protective order based on telephone calls and or text messages from December 24th, 2016 to January 3rd 2017, correct?
I don't recall. That's what hearing was.
Based on this complaint, that is what the complaint says, correct?
This complaint says that it was entered in February 8th, but it didn't get prosecuted until after I got out in around June. It was around June of 2017, if I recall right.
So I will move to attach the criminal complaint. Attached as Exhibit K as plaintiff's fourth trial exhibit.
Counsel, Mr. McDonald, I know that you've stated your objection for the record. That objection will stand.
Can I say one thing?
Sure, go ahead.
So this is that just is for the court to bear weight on it is a text message or phone call attempting to contact the applicant. There was nothing saying in regards to Candace. It was only in regards to his children and getting presents to the children. And that's what weight this count has. And there was no order saying I was not to contact. I believe there was none that said that I couldn't contact your parents at that time.
And you were adjudicated guilty of that charge, though, correct?
By no contest, yeah.
Do you, Mr. McDonald, do you feel that you carry any responsibility for what has occurred in this case, with you not being able to see your children?
Yes, in some regards.
What responsibility do you think falls on you?
In regards to what?
To not being able to see your children.
And my responsibility? Well, confusion for one. There were orders that were unfollowable in my eye. I didn't understand. They were contradictory. Me and plaintiff tried to follow the order as best that we could. We didn't understand it. We tried to get clarification, and I didn't have counsel, and asked Judge Hardcastle to clarify the orders. That I was shut down, wasn't able to speak, and they were not addressed, to my knowledge.
So no responsibility.
Do you recall
Zero.
Judge Hardcastle ordering you to get a psychological evaluation back in November of 2017?
I don't recall. It was so I was devastated by getting orders where I can't see my kids or property, so I don't remember too much of that.
Okay, but isn't it true that you have not received a psychological evaluation since November of 2017?
Since November of 2017? No, there was two previous evals. So
Yeah, he took a quiz on Facebook. He's fine.
Since November of 2017, when Judge Hardcastle ordered you to get a psychological evaluation,
there was
you
one.
have not.
No, 16. That's when she injured that. So you're correct. November of 2016. Yes, there was an eval.
In November of 2016, there was.
No, that you said that was ordered.
After November of 2016.
Yes, there was one after that.
Okay, have you provided any proof of that?
It's on record with the court.
But you didn't produce anything.
My previous counsel did not subpoena those records.
And is it your belief that you have followed every order of this court?
I have done my best to follow all orders of this court and the municipal court, as I don't want to go back to jail or.
Do you believe that you would have been sentenced to serve time in jail if you had been complying with all the orders?
I believe I did my best in my ability to follow the orders, and it wasn't an unwill. In our statute, it states that there is a blatant and willingness to violate those laws. I was not willing to violate those laws, and as you can see with the text
Did
message.
somebody force you to violate the orders?
In my opinion, yes. Yes, as counsel, as plaintiff said, come pick up the children, or you're going to lose your weekend, or I'll pick them up. So that's when, yeah, I tried to make a
But
judgment
assuming that that's the way it
She
really
said she
went
was
down,
there, so I wouldn't.
Assuming that's the way it really went down, couldn't you have just said that's a violation of the order? I'm not going to.
I did. If you look at the text messages on exhibits, what is it, 42? It says please follow the court orders, and it wasn't a willful and unlawful violation of this court's order. So if you look at that, I was put in a predicament where how do I
By court order, you were supposed to pick the kids up at 9 o'clock in the morning, right?
That I don't recall. I believe that it said that on those days. It did not say a time, if I recall correctly. I mean, we can look at the divorce decree and check.
So it would have just been kind of random. You just show up whenever.
That's why talking parents, we were supposed to be good co-parents and come up with a time if things come up. And that's what I believe the judge allowed. So yeah, if you want to look at those text messages, we could bring those up again. Where is it?
But you understand that when a court advises you that you are to have no contact with another party, that means no contact, correct?
So there was confusion on the no contact as we had talking
If the
parents.
court tells you that you are to have no contact,
And
do
I
you understand that to mean that there should be some contact or no contact?
No, I did not want any contact with my ex whatsoever. Only in talking to regards to our children through talking parents, which I was doing my best to follow. As we can see, the text messages on page.
Do you believe that you've ever had inappropriate conversations with your kids regarding this divorce case?
Ever inappropriate conversations? No, there was never inappropriate conversations. That's complete hearsay. I took the COPE class. I know what to say to my children.
Yes.
You write them letters from jail?
There was letters that were
Okay,
written.
what'd you say in the letters from jail to your kids? You wrote letters to your kids, correct?
I
Hold
don't-
on, no, one at a time. Did you write, when you were in jail in spring of 2017, did you write your children letters?
Possibly, yeah.
You don't remember?
Yes, Judge.
You did? Okay, how many letters did you write each of
I don't
them?
recall. It was.
Was it more than one?
Possibly.
Okay, so in letters to Mason, did you say anything bad about their mom?
I don't recall, Judge. Ever saying it was very emotional to be in jail and not see my children for over 6 months.
I understand. So tell me what you said in those
Well,
letters.
I drew them pictures. There was some
Okay.
letters that
What'd you write in the letters?
the pictures were.
No, what'd you write in the letters?
I don't recall all the things. I remember saying I love them, I miss them, and how I look forward to being their coach and being able to see them and all
Strawberry.
I think about them and pray about them each night. I wrote all those things. I love them.
And butter.
Daddy hasn't forgotten about them or abandoned them. I put those things in. And I also put some of that in regards to if when they get older, maybe they ever want. I don't know. Wasn't sure if they were ever going to get to my kids, but
Could Mason read?
Mason can read. Judge.
No, in 2017 when you were in custody, Mason was able to read?
Judge Mason can read. I spent.
No, my question was, in 2017 when you were in custody, could Mason read?
Yes, Judge.
Okay,
I
can
read them every night.
no, not whether you read it.
Sorry.
Can he read?
Yes, Judge. She can read.
Can Malia read?
No, she can't read.
Okay, so why were you writing her a letter?
It was mostly to my son, Judge, but
Okay, but why did you write Malia a letter in 2017 when you were in jail if she couldn't read? What was the point of that?
Hi,
I
Jeffrey.
think I addressed both children. It wasn't.
Well, just help me understand. I want to understand why you did that.
To what? To
Why you wrote them letters while you were in
So
jail.
how would you not want to?
No, not a
I wanted to
question.
communicate with my children and say talk to them as I had them every weekend for a year, and then almost every other weekend, and then nothing for 6 months being in jail. I wonder what they were thinking about me. Where did I vanish? Did I die? I had questions, so I wanted to send them.
You had questions, so you sent them a letter?
No, I wanted them to know what was going on. To
You
know.
wanted them to know what was going
No,
on?
not what's going on. where their father was. Why isn't Daddy here? Those
You
kind of
wanted to
questions.
tell them that you were in jail? Did you say in the letters, Daddy's in jail because Mommy put him there?
I don't recall, Judge.
You don't recall? Is it likely you said something like that?
It was very emotional. I don't know what was written.
You don't know? You don't know if you wrote that or not?
You know, these letters, I was going to keep them and give them to them one day or something if they ever asked her. And this picture, I just sent pictures to them at first. Those pictures
They're
were never
not-
brought up.
no.
I drew things for them. And
Not worried about the pictures. I'm worried about you writing these two little kids who can't read.
My
Okay.
son can-
All right. Let's assume Mason is a great reader for his age and he can read your multiple pages of why Daddy's in jail. Tell me why you want to tell him at that age that you're in jail and the reason why. I'm trying to get to your
Judge,
relationship with your son and your daughter, and I
Judge,
need more information
I
about
have a
that.
very good relationship with my children, and they would ask questions and things. I would do age appropriate questions or answers. When a child goes and asks you a specific question, as a parent, you
When you're in jail, were your kids asking you
Oh, Judge,
questions?
This was before.
That's why I don't understand why we would write them letters.
Judge, it was an emotional time. Things that when the children are of age, one day maybe they'll know what happened or what I didn't know.
Also continue.
So I'll have you look at exhibit that's been marked as Exhibit E. Is this one of the letters that you wrote to Mason and Malia?
Defendant's Exhibit E.
Plaintiff's Exhibit E. It's been base stamp PLA 000208.
So what about it?
Is this one of the letters that you wrote to Mason and Malia while you were in jail?
I believe so.
You believe so, or it is?
It's the words are written. It's
Would you like to review this for a minute?
sure. I'll take a minute to. I've not seen these.
You've not seen these?
No, I don't believe that you supplied those to me.
I did.
Did you? In an email? This person has pretty bad handwriting.
This person does. Do you know anybody else that would write to dearest Mason and Malia and title it Dad has been in
Oh,
jail for
just-
almost 75 days?
Did you write this, Mr. McDonald?
I believe so, Judge.
All right, next question.
I'd like you to review that real quick and then I'll ask you some questions about it.
Is this just for both of these?
Just this first page.
Okay.
Okay, you see any reference in there where you allege that you were ordered to pay your mom's attorney almost $30,000?
Yeah, that time I didn't understand that, but yeah.
Then you mentioned it could have been used to send you guys to college. I wish she would have just agreed to all when we sat down with our stepdads. Later on, you mention, I have lost everything in this divorce and your mom putting me in jail. Good job, house. And safe with your guys' savings, a lot more. I have nothing, and I'm going to have to start my life over again, and I'm homeless. Do you see that?
Okay.
Do you think that is appropriate stuff that you should be addressing with your children?
So, did the children ever see this?
That's not my question.
Well, you know, if you're thrown in jail and
The question is, do you believe that that is appropriate discussion for a 5-year-old and a 2-year-old.
Well, was he 6 at the time? No, I would not bring these. Some of these discussions would not be appropriate for.
You don't believe that's appropriate. But you wrote this out and sent it to them, correct? Correct?
I don't recall, and I don't believe they've ever seen this. So yeah.
You don't recall sending this to them?
I don't recall seeing it or sending this to them.
So you've never seen this before.
I believe, like I said, I don't recall seeing this.
But then you already admitted that you wrote this.
Did I admit that? This could be altered or things, but no, I don't recall my kids ever seeing this. There was an emotional time being in jail, but I wouldn't have an appropriate conversation with my kids.
Okay, I will move to admit this page, plaintiff's exhibit based on PLA 000280.
Any objection,
I'd
Mr.
like to
McDonald?
object to that as for the validity of this. It wasn't signed. There's no date on it.
You just told me that you wrote it.
I didn't say I wrote it, Judge.
You didn't say you wrote this 5 minutes ago? What did you tell me?
This it looks like some of my writing and things, but this could have been altered. There's no signature. There's no. I'd say based on just being a scribble on a piece of paper, you wouldn't be able to admit this. This is not original. I didn't write this copy here. This is not what I wrote. Do you like?
No, I understand. I think what your objection is that you didn't.
Validity or objection.
I get what you're saying.
There's no signature. There's no date on it.
You didn't tell me that you wrote this 5 minutes ago?
I don't recall if I said that, Judge. Did I? So just based on that, that's the. I don't know the rules of evidence, but I think it says that it has to be validated and stuff like that. And it hasn't.
Counsel, I'm not going to admit it.
Your Honor, he clearly admitted to writing the.
That's from his exhibit list. Those are from his exhibits, not hers. His.
I
heard him.
letter.
But I'm a little bit concerned about something else. So we are going to take a 5-minute break, and then we are going to come back.
We're at recess.
He's worried
We're
about
back
appeal.
on the record. Thank you, counsel, Mr. McDonald, for giving me a moment to review some documents. Thank you, Mr. McDonald, for giving me a moment to review some documents. Come on up back to the witness stand. I'm going to ask you to put your phone away. Counsel, continue.
Where are you currently living?
Close to UNLV.
Can you tell me your address?
I'd prefer not to, as I don't want to be stalked or.
You don't want to be stalked?
Judge, I've been being stalked recently, as per my evidence, and I would not like to disclose my address.
Okay.
But you're not currently living at 5812. Okay. That's the address you have listed on your most recent financial disclosure, correct?
I sometimes use it as a mailing address.
And whose address is that?
Stepdad.
Are you currently working?
I do odd jobs currently.
What type of odd jobs do you do?
Depends. Some computer stuff, some real estate stuff, cleaning up things like.
Okay, and how much do you get paid for those odd jobs?
I try to make it. I do as much as I can to make like $800 to pay my bills. Like at least $800 a month.
Okay, and you realize that you've listed on your financial disclosure that you make $0, correct?
I don't believe that's true.
Do you have a copy of your financial disclosures that you filed?
I don't think I do. I think it's in the exhibit list.
High security.
It might be over there. So I'm also a student right now. I'm doing my best to get work as I tried to get rehired at my old job and was unable to, as they have DoD contracts and they can't have people with domestic violence.
What are you paying for school?
I'm going for financial aid and scholarships.
You're submitting paperwork for that, or you already have that?
Nan, did you see my DM?
I submitted for financial aid.
But you're not currently receiving it.
I got approved. I didn't get approved for last semester, but I should be getting approved for this upcoming semester.
So you went to school last semester?
Yeah.
How did you pay for school last semester?
It was through financial aid. I think I still owe them some money on that, so we're still waiting on the funds for that.
When did you start it? And you're attending school at UNLV, is that correct?
Yeah.
When did you start attending school there?
The semester after I got out of jail. It's the winter semester of 2017.
Isn't that semester still going?
No, it's spring semester.
And on your financial disclosure, despite listing that you make $0, you claim $800 in business expenses, correct?
Maybe I filled it out inappropriately. That 800 is around what I'm currently going for each month. I'm doing my best to earn.
Okay, because you have on your business expenses, you have a car and truck being used for business that you spend $100 a month on.
That's a gas charge, I think. If I recall.
For insurance, $100.
Oh,
For mortgage or rent, $550.
$100 a month for insurance?
Are
Where?
you renting out an office space?
It's zone commercial and residential.
So you're living there?
Possibly. Yeah.
And utilities of $50, correct?
That's part of the 550. Yeah.
And so you have. So you list here that your average gross income from self-employment or business is $800, correct?
It fluctuates, yes.
And then $750 in business expenses. Okay. And then you also filled out the personal expense schedule, and you have a total monthly expenses of $1,050.
Yeah, so I also have a rental contract where I can have reduced rent for doing different jobs around, and it's my friend's house, so.
Okay, so is that a business address or is that a lease? So you're paying $550.
Nope. We can't just slide right past that one. A moment of silence for that poor friend. Oh, wait. There is no friend. He's lying out his ass again. Never mind.
For rent on a business and $500 for
No, that's
rent on an
incorrect.
apartment?
It's a commercial and residential place. It's a big place that I have. I also have beds for my kids. I have everything in place for them as well. They can live with it.
Okay, but if you're, as you say here, if you're making $0 a month,
I didn't state that.
I'm going to have you. You don't have a copy of your financial disclosure. I'll have you look at this. Can you just review that real quick, and then I'll ask you some questions.
Okay.
Does that appear to be your financial disclosure?
Appears to be.
Is that your signature on the back page?
So.
Is that your handwriting with your name at the top of the front page?
So.
Okay, and if you look on the second page, what does it state for your annual income? Up towards the top.
Year-to-date income, is that what it is?
Yep.
Yeah, I don't think I filled that out. It wasn't.
Does it have zeros written
Oh, I think it's question mark because I don't know exactly how much it was.
So those aren't
'Cause
zeros.
I was
right in that-
unemployed for
that
over.
category?
Oh, this year, 2018. Yeah. Yeah, I wasn't sure what to put there.
The record speaks for itself, counsel. I can see the financial disclosure form that he filed with the court that says gross monthly income 0.
Okay, so I might have divided by 12.
0, 0, 0,
Yeah,
0 divided by 12,
I didn't know
0.
how to put that.
Okay. Next question.
Guys, we don't know what's going to happen yet. He could be awarded full custody, and she get nothing. We don't know.
Isn't it true that you took a trip to Washington, D.C. recently?
Not recently.
Within the last year?
The year of 2018 or 17?
2017?
Yes, it's true.
After you got out of jail?
Yes.
When did you get released from jail?
I believe it was June 6th of 2017.
Okay, were you working at that time?
I was in jail.
So how did you afford your trip to Washington, D.C.?
How did I afford the trip? I had sponsored. My dad helped pay for some of it. I actually visited him as well afterwards. I haven't seen him in years and was able to spend quality time with my own
Did
father.
your dad live in Washington, D.C.?
No, he lives in Florida.
Okay, so you traveled to Florida as well? Okay. Have you taken any trips to California since you got out of jail?
Not that I recall. There might have been one. I had to go to Bakersfield to drop something off, but that's the only thing I can think of.
Have you made any trips to Carson City since you've been out of jail?
Not that I recall.
Okay, of all the trips that you have taken, how have you afforded to pay for those trips?
There was let me think. Like I said, I had some sponsorship on some things. Some people helped. Like my father, for example, paid for a lot of.
What were you being sponsored for?
Sponsored to, like I said, my dad helped pay for some of these trips.
So he
And
gifted you money?
My grandma recently passed away, and he's helping take care of her. And how she passed away, which the grandma my own kids never got to see. And she passed, and the house
That's
was
good,
cleared out, and
Snoopy.
I actually
That's good.
went
They're
to
going to
Florida
fix it.
and saw him and spent solid time with him. And
You'll be okay.
He moved back to Vegas. He actually moved back to Vegas recently. So
Okay, since you got out of jail, have you attempted to find gainful employment?
I have actually, yeah. I did apply for a couple of jobs as I'm going to school. So I'm
Have
trying
you
to.
submitted applications?
I did.
Did you provide any of those applications for court today?
I didn't know I had to, but I did get it denied because of the criminal charges. So, but I'm doing my best to get into real estate, and that was help sponsored, and I plan on being a great realtor one day, and along with studying the law. So.
Do you have a real estate license right now?
I actually just took the test, and I got 72 out of 75, so I'm retaking it very soon. So I should be one pretty soon.
Okay, have you provided any proof that you have taken the test for your real estate license?
No, I had to.
I have no further questions, Your Honor.
Anything?
gonna
Do you
be
have any
okay.
other witnesses?
No further witnesses.
All right. Mr. McDonald, is there anything else you need to tell me in a testimony kind of way before we get to closing arguments?
I would just like to say that continuation of there's a lot of things that were never rebutted, or a lot of evidence, or lies and complete libel and slander that have been perpetrated by the council that I never had a chance to. I didn't have effective representation that presented that.
Okay.
And I would like the court to take that into weight. And this should be a matter of joint physical custody, which there should not be denied access. Now I understand the judge's concerns about different things, and especially when lies that were rebutted, I didn't understand the rules of the court. I didn't understand that you had to refute those things or file pleadings. I had to almost become an attorney. And I don't agree with that in this system. I really believe that we should have proper representations. There's so much to law. I study in the law library a lot, and I don't think I'll ever be able to know all the laws in there. There's books upon books and codes that will never. No one man can know all the law, and it's the
Okay.
interpretation.
Anything else you want to tell me about custody?
In regards to custody, the judge, I would
Or you want to?
I like to save it for my, I guess.
Oh, okay. You take all your stuff back over there. We're going to have closing arguments now. Mr. McDonald, you're going to go first. I'm going to give you 15 minutes or less. And then council's going to go. I'm going to make my decision today. I'm going to issue my decision. Then a written decision will more specifically describe each and every element and each and every fact I found. But I'll give you a specific decision today. And then we have some other dates we need to set. So go ahead, Mr. McDonald.
Well, Judge, I understand that today's hearing is based on custody, and since it's been over 450 days, Judge, since I've last seen my children. There's no warrant for that, Judge. I wish there was a way and that's why I tried to file a bunch of different things. I didn't know what to do in this court. I just wanted to be able to show, look, this isn't what happened. I've made a lot of mistakes in the past 3 years. A lot of emotions are there, and so many things that I had no clue. I learned so much, Judge. I learned about our legal system. I learned I've never been involved in the legal system before, even though I've got some family that are. But I just ask that Judge look through the lies and see and understand the benefits of being a father and the psychological issues. And I've presented in my case study, in my CAP study, and other means and expert reports. I want my children to have healthy, good, loving relationships between both parents. It's in their best interest to have a mother and a father. And I feel as though my parental rights have been completely stripped of me on warrantless hearsay and different things that no standard of evidence as well, Judge. Just things saying that this is so, and no proof, not beyond a reasonable doubt. I'm still kept. That's why I asked for a hearing, and as soon as I got out of jail, I wanted to see my children. And yeah, there's a lot of recovery, and I did a lot of that in jail as well. But I've never experienced that. It was an eye-opening experience, Judge. I was able to help minister a lot of guys in there, and then there's so many people suffering and being thrown in jail for frivolous reasons, in my opinion. And I believe that our prison system should be a way of reforming people and making them
We can
better.
spend your 15 minutes talking about the prison system and reform.
Let's talk about just.
All right, but let's talk about, I'm going to keep you focused. I'm going to help you out here. Let's talk about your children and your request to modify.
Okay, first of all, I want to bring up NRS 125C.0035, as this is on my pretrial memorandum, that first of all, we need, in determining, after an evidentiary hearing held pursuant to subsection 5, and this is NRS 125C.
Snoopy, thank you so much. Thank you.
And section 6. So if after an evidentiary hearing held pursuant to section 5, the court determines that each party has engaged in acts of domestic violence, it shall be possible that determine which person was the primary aggressor, in which determination the party was primarily the physical aggressor for purposes of this section. The court shall consider all acts of domestic violence involving either party, the relative severity. So there was no acts of domestic violence previous to that hearing, Judge. That there was nothing on record. There was no acts that was perceived that were
Talking about before August 2016
before
or after?
Before, Judge, yes, and
Okay, so
afterwards.
remember that I'm focused on
So since
what happened after
so
August.
since since the last order of this court, there was
Lacey, thank you.
there was
Thank you so much.
a presumption or a conviction of the domestic violence. That conviction is on appeal, and there was denied due process of law. There was a max sentence, Judge. There was a lot of things that happened in that.
What was the due process violation?
One that I was denied equal access of protection of law. I was denied my right to an attorney when I asked for a paid one. I was also asked.
You had a public defender, though, correct?
Yes, but
you wanted a paid attorney. What is a paid attorney?
I wanted to hire private counsel.
Did you hire private
I
counsel?
was unable to.
Why were you unable to?
First, in my financial situation, after
You didn't have the money?
Well, I wasn't able, even
Who did
allowed
you,
to look.
who did you want to pay for it then?
I somehow I would have come up with something that I didn't understand the severity of those cases. And if you look in the pretrial memorandum, I mean the appellate briefs,
You outline it there? Okay,
Yes,
thank you.
Judge. So answering all this, all prior acts of domestic violence, the defendant has no prior history of domestic violence. The severity of the injuries, if any, inflicted upon the persons involved in those prior acts of violence. The allegations, and it was false, that the defendant pushed plaintiff, and that he didn't slam her, broke her nose, or slammed her against the floor. There was no marks, there's no blood, but pushed her. The severity is clearly a factor this court should consider. And if you look at the appellate briefs, Mr. Niddick did a good job in describing what that situation. Subsection C, the likelihood of future injury. There is no likelihood if orders are made for public or not in-person exchanges as the defender desires. There's no likelihood of injuries. We did the exchanges. We're good co-parents. There's no reason for that. I have a suspended sentence. There's no. I'll do my best to follow any orders of this court. Whether during prior acts that one party acted in self-defense, there's even allegations she pushed me at the daycare and different things of punching that was never addressed or never presented. And I had evidence that could have helped with that. But E, the factors which the court determines relevant to the determination. Defendant's history as a good and loving father is relevant. I had my kids every weekend. I used to take care of them. I'd watch them when she'd go to night school. The kids, it's in the best interest of the children to see their children. And the harm done by plaintiff's abuse of process and setting defendant up should be as relevant. So that is one thing. Another section is NRS 125C.0035 deals with the best interest of the children. In any action determining the physical custody of a minor, the sole consideration of court is the best interest of the child. The further states the factors in considering the determination and best interest of the child. A, the wishes of the children. If the children are sufficient age and capacity, intelligence, preference to his or her physical custody, I would ask this court to allow Mason to come in here. He's 6 years old. He's way beyond a normal child. It doesn't state exactly age. I think if he was in here, if he wasn't completely poisoned, or if he was able to speak, he would say how he loves his father, wants to be with him. B, the nomination of guardian for the child by parent. Defendant nominates himself as he would not cut the other parent out of the children's life. I've always encouraged a relationship between the mother and as I showed her, we both agreed to Christmas visitations, other things that it never allowed defendant, even his birthday. He asked for his birthday, he asked for Father's Day, would always be denied. And under our statutes, that should be one of the highest expectations in order. So this is the order that should be determined by this court. C, the parent is more likely to allow the child to have frequent associations and continue relationship with the non-custodial parent. Clearly, this is the defendant. It cannot be denied that the plaintiff has abused process and used the TPOs to beat the defendant and set him up for the violations. So, she has not fostered any frequent associations. She's in fact tried her best to alienate it. You could see her testimony is, you shouldn't see the kids, and saying how bad a parent. That has not been said. I could have a lot of witnesses
Mr.
coming.
McDonald, she didn't say that right.
She said she insinuated it, Judge.
She didn't say you were a bad parent. Do you remember what she said?
I don't even think she wants this to happen, Judge.
No, I think she does. I want you to hear what she said again. The kids need you, but they need you to be healthy and make good decisions.
And I think that I've proven that, Judge. All the things that I've done.
I want to make sure you heard that again. Her position was, the kids need you. She wants you to be a father. She wants you to be in their lives. The kids love you. But no. I want you to listen. They need you to be healthy. Did you hear that?
Yes, Judge.
That was her position.
And that's why I tried to clarify what is healthy, what do I have to do, what mountain do I need to climb, dragon I need to slay, what do I need to see my children? That's why I asked her, and she can't give me that's why I asked this court, like, what do I have to do? I just want to see my children. That's all. Like, I want to be in their lives. I want to be a good father. I want to go to the events. I want to go to their birthdays. I want them to know my family as well. So that's all. That's what I want. And this is the ability of parents to cooperate Sadly, the plaintiff is bent on winning. She has lost sight of what is best for the children and would not co-parent. The court will require the plaintiff to attend co-parenting classes. This would benefit the children. The mental and physical health of the parents. There's no significant mental or physical health issues of the defendant. Defendant cannot speak to the plaintiff's mental or physical health. However, it's evident that she suffers from pathogenic parenting. The exhibits show her giving defendant her gate code and having him go to her Starbucks and tells the court that she is afraid of him. During the marriage, defendant was never alleged to have convicted domestic violence, never charged with domestic violence, never had police at the residence. If truth be told, plaintiff was physical to defendant, and the marriage dissolved after the plaintiff resumed an affair with someone on Facebook and Christian mingle while married. The physical development and emotional judge. I want to be there to foster the development of my children. I know that effect of not having a father. I know that kids need their dad. Like they're, the people I talk to that have been suffered so much by not having sexual. Yesterday we had an author come in. Her name's Samantha Jada. She was sex trafficked as she was denied her father. And she actually got some legislation passed in California, and she's been doing great things out there. The nature of the children, the nature of the relationship of the children with each parent. The parent have a good relationship with both parents, and they need until pathogenic parenting of plaintiff. The ability of the parents to maintain a relationship with any sibling. The history of the abuse. There's no history of parental abuse or neglect on part of the defendant. Whether either parent or other person seeking physical custody has engaged in acts of domestic violence against the children. Now that is K. That's on the lower standard of all these other ones, and I believe that bears weight on not allowing meaningful.
Oh, you're saying that because of the list of the best interest factors, I should give more weight to the first factor.
It says that, Judge. Yes.
Rather than the last factor.
That's written in our NRS statutes, yes, Judge.
Right.
And there has been no abuse. There has been abuse of process by the plaintiff. The allegation is defendant pushed the plaintiff. Pursuant to NRS 48.125, defendant pleads no contest, should not be considered in the action where the parents or any other person seeking physical custody have committed any act of abduction. Since defendant's primary objective is to remove or minimize the plaintiff and his children, there's nothing less than attempted act of abduction. I've never abducted my children, Judge. They have claimed I tried to abduct my children. Never have I done that. That's complete hearsay and lies. I wouldn't do that. I know there's a felony charge. Why would I? And also, why did I go?
What were you doing at the daycare that day when you picked her up off the mat?
Judge, I believe that was my day for custody, as I had every other weekend that was ordered by this court. So I went to go pick up my daughter.
No, you were ordered the 2nd and the 4th, the weekend defined by the first Friday of the month.
Yes, Judge.
So you thought that was your second
I believe it was the second Friday, yes.
And so is that how you normally go in and pick up the kids? You just
Judge.
go in and sweep them off the mat and walk out? Or do you go in and you sign them out and you get their backpack and you walk out?
That day I went early because there was a doctor's appointment that was scheduled. So usually I go over, after I get off work, which was around 4 or 5 o'clock. So that day I went there around 2:30, I believe, and then she must have just been getting off work and ran up and started shoving me, and it was an altercation there.
No, I'm more concerned about you taking the kid off the mat and it being the wrong kid, and then you getting the
Judge,
and then you walking out. You know, that looks really bad, Mr. McDonald. But I need an explanation. I never got that from you today through all of today, all of the time that I gave you.
Yeah.
Why was that going on?
Judge,
Why are you?
I didn't try to take somebody else's children. There was dark in the room. There was
Well, it
mats
was
in there.
nap time.
Yeah, so it was nap time. I go in there and looking for my child, and I saw a person there. I didn't grab their child. I said, "Oh, that's not her." I didn't pick that child up.
Did you touch her?
And I asked, "Hey, where's Malia?"
Did you touch her?
No, I looked. They were covered up over the head. I saw blonde hair. I thought it was my daughter.
Lies.
So I did not pick up that child. I don't even think the child woke up, if I recall right. And then I asked, "Where's Malia?" She pointed over there. I grabbed my daughter, and she woke her up. She was okay, a little groggy. And then I walked out. As soon as I walked out of the door, Candace runs up and, "You're not taking her." He started cussing and stuff and started shoving me, Judge. So she has these bouts of rage or whatever and anger that it was through the marriage. I never laid hands on her, Judge. I wouldn't do that to somebody. I know better than that. All right, I did some emotional things that
You keep saying that you did emotional things. I don't really know what that means, and I don't know what. So if
But
you
trying
want
to get her, trying to get her back and trying to do. I'm done with all that, Judge. You
so
know,
that was the emotional things that you say were a mistake, was trying to get her back.
emotional things, confusing the orders. I didn't understand how to follow. Like, Judge, there's a lot in this case that
Okay, well, in the future, I need you to make sure that you understand every single order before you leave the store. So I'm going to ask you a bunch of questions about every single order every time, okay? And the reason is because you're telling me you're confused about a stay away order, you're confused about the TPO, you're confused about the custody arrangement, you're confused and you didn't know if it was a criminal trial or not. Okay, so I'm worried that you're not understanding everything that's going on. So from here on out, no offense to anybody, but we're going to take a lot of time. When I make an order, I'm going to ask you a lot of questions and make sure you understand it before you hit that door. You understand?
yes, Judge.
All right. Okay. Keep going.
Okay. So let's see. Oh, there is a statute called NRS 125C.020, rights of a non-custodial parent, additional visits to compensate for wrongful deprivation of right to visit. As you can see in my exhibits, the exhibits of the Thanksgiving weekend I was supposed to have, she denied those visitations. I have those police reports on there. I have when denying Christmas, denying birthdays, emails between her counsel trying to see the children. So I would ask her for some kind of compensation time to be able to see my children. I miss out. I can never make up a year of my children's lives. Memory of the right of first refusal. If somebody wants the kids, I should be that person to watch them, or given that right first, as I'm their father. If they don't let a babysitter watch them, or I'll afford the same thing to her. If anything, hey, you want to watch the kids? I got this going on. And if she said no, then I would come. I'm a father. I would take the appropriate steps to find find an appropriate babysitter that would watch my children. So, and take an additional, so that was in a dispute concerning, right. And there was also NRS 125C.0645, the form of an agreement. We both agreed to things, and we had one before we came to court, and then everything got degraded. I believe that we both can come up with a visitation or a custody exchange and custody thing by ourselves, if possible. We can both say, hey, this works and this works. I know that we're both adults and that we can have those disputes. If there wasn't a matter of primary or not whatnot. Let's see. And I went through those NRS 125 statutes. There is a case called Barbagallo versus Barbagallo, which is the proportion that this court should not adopt it should adopt a 40% timeshare requirement is displayed. So this was in determining the factors of the court for joint physical custody of when there's a determination, and it clarifies that arrangement constitute primary and joint physical custody, and that I would agree that if we could come up with some kind of time of 03 overnights, that would be agreeable. Sevely versus Sevely, a party seeking modification of custody provision of a divorce decree bears the burden of demonstrating that a material circumstance of facts affecting the child's welfare has occurred since the initial divorce decree, and a modification is in the best interest of the child. So Sevely versus, in regards to that there has been lots of change of circumstances, and one of them is being denied access to their father. They should be able to see them and have a meaningful relationship with them. I could go on. Ellis versus Carucci, that is another one that's in place. There's a lot. I could keep Castle versus Simmons, Pena versus Pena, and there's Mosley versus Felizaguli. And there's one more thing that I would like to say, Judge, is that
Snoopy, thank you. Epic Drunken,
there
thank
was a
you so
landmark
much.
case
Thank you.
That was put in place for determining custody and put in our NRS statutes. I believe that was 140, NRS 148. I'm looking for it right now. But we have a set standard of what this court should follow in regards to determining custody matters. I know it's what is in the best interest of my children. I mean, our children. I know what, and both of us will both agree to what happens, and I think it's best for them to see their father and to have meaningful time with them, and to help the father to help bring them in the world, to be there for holidays, to be there for events, to have them to bring in meaningful trips and memories, to have good co-parents to help raise them, and I think that.
Yay, Judy.
That I've proven, Judge. I've done everything this court's asked and more. There's the counseling, the thing. What else do I have to do, Judge, to prove to this court that I'm a fit, willing, and able father? And that's what I'm here today for, to show. Look, this is a case, extreme case of parental alienation, and it's going to cause deep issues with our kids. I hope that right now they're young. I really hope that we can remediate that before that happens. And I'm going to continue I want to continue to have meaningful relationships and build that relationship back up with my children. And I don't know how for this over this year is going to how I can ever make that up with my children. But I know I can show this court that I've remediated by myself or changed it, and to see the issues. And there's also in our statute that in determining custody of a child when that if a parent it causes the parental or prevents time with the other party, that they be awarded compensatory time, or that a lot of case laws where it's reversed, where the custody is brought upon the defendant over the plaintiff. And I believe I've proven all that case. And if you could see the evidence that I've had, the baiting, the entrapment. Has she ever been hurt? And during since your last order, Judge, I've stayed far away from her. I've done everything I can to follow this court and the municipal court's order, and to become a better man and a person that my children can look up to one day. And I ask that you take that into weight when considering joint physical and legal custody of my children, Judge. And I thank you for that. And I'd like to. Is that my closing statement? Or?
It is. Thank you. Counsel?
Your Honor,
You can have a seat, Mr. McDonald.
I do find it a bit intriguing that defendant wants to feign ignorance when it comes to following orders, following any recommendations by the court, yet is able to come in today and cite statutes, cite case law, cite all these issues, but yet is somehow, when something doesn't go his way, is ignorant and doesn't understand what he was supposed to do. Today we're here on defendant's motion to modify. He carries the burden of establishing that there has been a substantial change in circumstances affecting the welfare of the children, and that it is in the best interest of the children to modify the current custodial arrangement. Today he has brought in no evidence that the circumstances have changed. He's readily admitted to being adjudicated guilty of 3 violations of a protective order. He's admitted to being adjudicated guilty of battery, domestic violence. He has an inability to accept any responsibility for his actions, which is probably the most concerning thing, that there's no way he can get better if he doesn't understand that he's done something wrong. And today we've sat through hours and hours of testimony of him trying to show how Candace is wrong. I've been baited. I've been entrapped. But yet he provides no proof of any of this. He claims that he's been compliant with everything the court's ordered. He's done nothing that the court's ordered. He didn't produce any of the evidence timely in this case. He didn't do any discovery. He didn't produce anything to show that there's been a change in circumstances or that it's in the best interest of the children. Adversely, we've only seen evidence. He wants to focus on Candace's boyfriend that has been definitively proven to be somebody different than what he thinks, but he cannot let that go. He was ordered to get a psych eval. He chose not to do that. He's been ordered to do domestic violence classes. He's produced no evidence other than the 15 that were done. While in jail, he's produced no evidence that he's actually done any classes to help better himself. And he continues to say that he wants to be a good father, he wants to do everything, yet his actions show completely different. And like Candace has testified today, it's not her intention to alienate their father, to kick their father out of their life. Adversely, she wants him to be. She knows, she understands that it's good for her kids to have a father, but he has to be healthy. He can't be talking about very sophisticated court things. He can't be doing YouTube videos and saying that he wants to do something to Candace. He can't be out doing things that are contrary to being a good father. It is our position that there's been no evidence presented today that would justify a modification. That we believe that if defendant is ultimately able to complete domestic violence classes, if he gets a psych eval and gets the help he does the counseling, does what it takes to where he can be a productive father and not harm the children with his actions, that eventually supervised visits can be reinstated. At this point, there's absolutely no justification for joint physical or joint legal custody, and we would ask that, based on the evidence that's been presented today, that we maintain the status quo until defendant can show that there has been a change in circumstance and that it is in the best interest of the children for him to gain supervised visits or
child support. Don't forget
Thank
child
you,
support.
counsel. Mr. McDonald, briefly, in reply.
Again, Judge, counsel is poisoning the well further, saying that there is no evidence that was presented. Judge, there's a stack of evidence here, 80 pages or more of evidence and things that show that are relevant to this case and changing it as a change of circumstance. There's a mountain of evidence of things that have changed in the circumstances of this case. And again, to poison the well and to come up with complete lies, just to throw them on the wall and not rebut, and to say that I haven't complied with the court orders. I've done the classes, I've done the counseling, I've done, what else do I have to do? You know, I still plan on attending these groups and see, I'm bettering myself, Judge.
That question hurts my heart.
I learned so much. I didn't know every little detail of domestic violence and this thing and control and what is it? There's so many things that I learned over this past year. I'm better for it. I mean, I'm not gonna. I will admit that I made a lot of mistakes. This is the most tumultuous time of my life. It's torturous not to see your own kids, Judge. I can't tell you. I can't even sleep at night. You think of your kids. You pray for them every night, and you can't see them.
I don't know if it's torturous not to see my kids, but I'd be willing to give it a try.
You don't know how they're doing. Judge, if you have children, you understand.
For a week or two.
Mr. McDonald.
Judge, it's so.
Don't go there with me. We've
apologize.
been there before. Do not mention my children
I
in this
apologize.
courtroom ever again. Do you understand me?
I met a person that has children, Judge. I apologize for that. I'm sorry. What I would say is that it's devastating, Judge. It's torturous to not be able to see your children. If you ever watched the movie Miss Doubtfire, when he goes and dresses like a woman, he goes in there, becomes their nanny, and does everything he can to be in their lives, even if it has to be being their provider. It's because people go crazy, Judge. They want to see their children, and most people are good parents. They love their children. They'll do anything for them. And to separate it because of money and because of vindictiveness, it's not best for the children, Judge. I was a great dad to my children. I would spend time with them so much. I would teach them things, never put them in front of the TV. We'd go swimming. We'd do all these things together. And my kids are awesome, amazing children, Judge. And I wish I could bring him in here and he could even attest to that, you know. And I don't even know if I'll recognize him. He was about half my size when I last saw him. He's probably like, I don't know. And my little girl, she was 2. She barely talking. I just taught her how to walk, and she was. I just want to be a father, Judge. I didn't have children not to be in their lives, and I take responsibility for me to be in their lives and to do that. And whatever this court finds, I'll do whatever it takes to see my children and to be co-parents. I'll stay far away from her. I don't want anything to do with any kind of allegations. I'll make sure I record everything and have a witness or whatever it takes in that regards. And I would like this court to order set things that make sure that something like this doesn't happen or set up. I'll make sure that wouldn't. I never thought that would happen. And I've been, Judge, it's emotionally devastating. I mean, to lose my house, my job, my means of income, like I was planning on giving my house to my children one day, like I just can't believe this. And now trying to buy a house in this market, it's crazy. So, Judge, I ask that it is in the best interest of the child. I've had a burden of proof to show this court that it is in the best interest of the children to have their father in their lives, to have a joint legal and physical custody. And I've showed this court that there was evidence of the parental alienation and pathogenic parenting. And I ask this court to take weight to that as per our statutes, and that goes through to each one, and that you are able to give the domestic violence weight in what it is, as it states in our statute. Is if there was evidence of it, there was a severity of that. I'm not a woman beater, Judge, and what counsel would probably try to negate. I love my children. I just want to be in their life, and not being able to see them in a year, it's been devastating. I've overcome by God's grace. He's helped me so much in this, Judge, and and this is what things that's keeping me going. To my relationship with God, and I thank Candace for that too. We used to go to ministry together. We used to go to these things and she helped bring me closer to Him, and He's been helping me through this difficult time. And I hope that you can see that Judge, and know that I'm a good, fit, willing, and able father for my children, and that I have shown you the change in circumstances, and that I am a remediated man, and that I won't do it, that I will follow this court's order, and I'll do my best to be a good co-parent and good father for my children. Thank you.
Mr. McDonald, your motion to modify custody is denied. There has been a change in circumstances. You've been convicted of 3 TPO violations and 1 domestic violence. You have done absolutely nothing. There is no mountain of evidence to rebut the presumption. She will continue to have sole legal custody and primary physical custody. All visitation, including supervised visitation, remains suspended. I will issue a written order forthwith with findings of fact, conclusions of law. Now,
Judge, can I rebut to that, please?
no.
There's
Now. You submitted to this court and filed with this court on March 13th, 2018, your exhibit list. Included in that exhibit list, I'm looking at page number 7, that's your proposed exhibit number C, letter from counselor. Dated August 31st, 2017, it's a letter to me, the Honorable Linda Marquis. It's interesting, I had some questions about that last sentence.
I'm going to start a GoFundMe.
In that first paragraph, I was kind of concerned about it. Asked you about it a couple times. Counsel asked you about it a couple of times.
I asked the
Turns out, and you're not going to talk right now. Turns out on September 27, 2017, you filed a reply to an opposition and counter motion, and attached to that on page 18 was a letter from the counselor. That letter is dated August 31st, 2017. It's the same letter. Same letter to me, and guess what's not there?
Oh my gosh. Oh my gosh. She warned him. Guys, she warned him. Oh no. Oh, he's going to jail right now. He's going to jail, guys.
That sentence in the first paragraph that says, I do not believe Mr. McDonald is a harm to his children or himself. So I guess my concerns were right. You, my friend, were attempting to defraud this court with fake evidence. Now, you are not going to talk. I'm going to appoint counsel to represent you, because now your Sixth Amendment does kick in. And you will face criminal contempt charges in front of me. And I will appoint you counsel free of charge. So I'm going to see you back next week.
Judge, I did.
No. Do not talk to me about this now until you have counsel present. Wednesday, March 21st at 1 p.m. for appointment of counsel. Counsel, I'll need you there as well. Your client's appearance is waived. On that date, I will issue the order to show cause. It will come from the court. And then we will set the order to show cause date, and we'll make sure that your counsel is available on that day. We'll look at it on our calendars and see how much time they need to prepare. Counsel, this counselor, no. I am not going to let you speak right now. You are facing criminal contempt. Anything you say will be held against you. Do you understand? I am not letting you speak. Counsel, this counselor, Nancy Sargent Hunterton, she will need to be subpoenaed for the order to show cause date. She will appear in this court and testify about that letter that she wrote to me, that she provided to Mr. McDonald. Not on the date next week, but on the show cause date. All right, counsel, thank you so much. Good luck to everybody. Have a great day.
Judge, we're really supposed to be in the movie one day.
Go. Get her. Pack your stuff up. Time to go.
You're in contact, huh?
Don't talk to me.
It's been a freaking year, man.
Yep, I'm going to.
Bailiffs are mad at him.
Yeah. I know, you can't say anything. A year.
He's not allowed to leave until Candace is gone.
Go. Go. Sure. Huh? Sure.
This is the matter of McDonald versus McDonald, D 15-518-905D. The parties are not present. Counsel, your appearances for the record.
Russell Collins, bar number 11363 on behalf of plaintiff.
Your Honor, Christopher Tillman, 5150, here per the Indigent Defense Counsel. Your Honor, when I spoke to Mr. Christensen yesterday, I didn't get a name as to who I was being appointed to, and as the court's aware, I've been appointed more than once to these new cases where we have this
Lewis
Supreme Court
case, yes.
decision where if jail time is in the offing, they must have counsel. But Mr. Christensen did not tell me who the individual was. The problem is I have an indirect conflict on this case, and given the tenor of what's gone on, I just don't believe I can represent Mr. McDonald given my conflict.
Counsel, do you have anything you want to add or any questions for counsel?
I talked to counsel just before the hearing, and he's, my understanding is he just has he can't disclose, and I don't want to force him to disclose stuff that he shouldn't.
No, and
but,
certainly the court's not, but
But I agree. If there is a potential for conflict, bias, whatever it is, based on what has already been filed in this case, I would suggest we find somebody that isn't going to have any issue whatsoever, whether it is a conflict or not. I would say we just stay as clear as
Thank you, counsel. Thank you, Mr. Tillman. I'm going to make a quick record. I'm going to ask you to stay for that. and then I'll tell you how we're going to proceed today. Mr. McDonald's accused, and you can have a seat, of abusing the process or proceedings of the court in violation of NRS 22010 sub 7 by filing with the court and offering into evidence a document knowing the same had been forged or fraudulently altered relative to an issue properly before the court, a modification of custody request. In proceedings initiated by Mr. McDonald in the matter of McDonald versus McDonald D 15-518-905 in the 8th Judicial District Court, Family Division, State of Nevada. For the record, Mr. McDonald just walked in. More specifically, it's alleged that Mr. McDonald abused the process and proceedings of the court in violation of NRS 22010 sub 7 on or about March 13, 2008, by filing with the court a document entitled Exhibit List, which both discussed and attached proposed Exhibit C, a letter from Nancy Sargent Hunterton, M.A., L.M.F.T., Nevada License 0988, at Character Way Counseling, Coaching, and Consulting, addressed to the Honorable Linda Marquis, dated August 31st, 2017, knowing the same had been forged or fraudulently altered. In addition, it is alleged that Mr. McDonald further abused the process and proceedings of the court in violation of NRS 22010 sub 7 on or about March 15th, 2018, by offering the same into evidence, proposed Exhibit C, a letter from Nancy Sargent to the Honorable Linda Marquis, knowing the same had been forged or fraudulently altered. Further, it's alleged that Mr. McDonald further abused the process and proceedings of the court on or about March 15th, 2018, after continuing to offer into evidence, after being questioned by the court, and objections to the same from counsel about the inconsistencies and strange appearance of proposed Exhibit C. However, Mr. McDonald persisted regarding the same letter, knowing the same had been forged or fraudulently altered. This issue of contempt is unique in that the request for contempt proceedings was not made by the opposing party. Instead, the court, sua sponte, is setting this matter for hearing. The court developed serious concerns regarding the authenticity of defendant's proposed Exhibit C throughout the course of an all-day hearing, and the court posed questions and made clear to Mr. McDonald and on the record its concerns relative to the authenticity of that document. During the hearing, upon closer review of the underlying pleadings filed by Mr. McDonald, the court discovered that he had filed an almost identical document with the court just months early. The almost identical letter was filed with the court in the same action on September 27, 2017, and was marked as Exhibit 1 to Mr. McDonald's reply to opposition and counter motion, to plaintiff's opposition to emergency motion, to reinstate joint legal and physical custody for a regular visitation schedule, emergency motion for an order to show cause, emergency motion for reconsideration on erroneous orders, an order to compel plaintiff to reimburse Michael for the loss sustained from the improper sale of the house. A comparison of the two documents reveal that the revised letter filed in the exhibit list on March 15th and offered into evidence on March 18th contains an additional sentence at the end of the first paragraph that states as follows, quote, "I do not believe Mr. McDonald is a harm to his children or himself." This additional sentence, alleged alteration, fraudulently, strikes at the very heart of the matter pending before this court and impacts the court's primary consideration in all child custody matters, the best interest of the children. The district court has the inherent power to protect the dignity and decency of its own proceedings and to force its decrees, and thus it may issue contempt orders or sanction parties, dismiss an action for litigation abuses. Further, the district court has the inherent power to prevent injustice and preserve the integrity of the judicial process. The court's ability to carry out its constitutional duty and to ensure the administration of justice was impacted, or perhaps impacted, by Mr. McDonald's actions. Accordingly, upon a finding of indigency through a review of the record, the court's appointing counsel pursuant to Mr. McDonald's Sixth Amendment rights, as discussed in the Lewis matter. Counsel has indicated that he has a conflict. He hasn't disclosed the conflict, and I'm not asking him to. However, we'll set this matter over for confirmation of counsel.
Judge, I would like to
The court is mindful of its duty to sit. However, the court is further concerned about the unique way in which this issue came to light. The court engaged Mr. McDonald in a significant colloquy regarding proposed Exhibit C, and further, it was the court that later discovered the prior version of the document filed with the court months earlier. In light of the court's interrelated, connected relationship with the allegations raised herein, which are the basis of the order to show cause, and the appearance that the connection might create, the court recuses itself from the order to show cause hearings and any other hearings that flow from the order to show cause. The court understands and has considered NRS 22030, which directs that if contempt was not have alleged to occur within the immediate view of the court, as in this instance, the court in whose contempt the person is alleged to be shall not preside at the contempt trial over the objection of any party. However, pursuant to subsection 3B, this provision does not apply to matters under the jurisdiction of family court. A review of the legislative history indicates that this portion of the statute was amended in 1999 through AB 154, which further developed and tied up loose ends in the one judge, one family policy to include contempt. The minutes of the Nevada Assembly Committee indicated that Barbara Buckley argued that the parties in family court utilize requests for orders to show cause too frequently, and consequently, the idea of having another judge hear these matters was allowing litigants the proverbial bite at another apple. Here, request for order to show cause has not been frequent and has not been repetitive. Further, the facts and circumstances that give rise to the current contempt allegation were discovered by the court itself during the evidentiary hearing. This was not a request for a contempt hearing by another party. The court sua sponte set the hearing, and the court is concerned about the gravity and severity of the alleged action. One judge, one family cannot be construed to inhibit the inherent authority of this court. Further, mechanical rules imposed by one judge, one family cannot imprison the inherent authority of court. Out of abundance of caution and the need for transparency, the court recuses itself. The order to show cause will be randomly reassigned.
Judge,
At that hearing, at that next hearing, in front of that next judge, there'll be a confirmation of counsel. Mr. Tillman, I know you're not representing Mr. McDonald in this matter, and I understand. Before Mr. McDonald speaks, I'm going to let you know again that anything that you say could be used against you in a future contempt hearing, and I caution you. All I'm doing today is recusing myself.
Judge,
So if there's
I would
something-
also ask that you recuse yourself from the divorce matter entirety as prior canon violations. One, a judge shall uphold, promote, and the independence, integrity, the impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Judge, there are so many means to recuse yourself. For one, you were the judge over my parents' case. You went to law school with my cousin Joe Bonaventure. You also, your law clerk, Connie Domingo, was also the clerk for my cousin and my uncle, and there's bad blood between them. There was no discovery done. There was a talking of your husband where you were about certain things of attorneys being shot in my case, which was discussed against client attorney privilege. There's a multitude of things that you should recuse yourself under this case, and the defendant seeks an impartial party, impartial judge, an unbiased judge. And I believe I come to you on a means for custody. I haven't seen my children over a year, and my parental rights were completely terminated. Now I have no clue when I can see my kids, or no path to where I can see my children. So based on Canon 1.3, avoiding abuse of the prestige of judicial office, a judge shall not abuse the prestige of judicial office to advance the personal or economic interest of the judge or others. Judge, you also had a personal relationship with Kurt Smith, and he rewarded him $3,500. You've awarded counsel $25,000 in marital assets. All my property and over 140 and over almost $250,000 in marital losses. I'd also ask that based on Canon 2, a judge shall perform the duties of the judicial office impartiality, competently, and diligently. I say that there wasn't an impartiality, as you were caught saying you keep me up at night, and I'm going to punish you. You've also had statements of, I'm going to protect you, your ex and your children from you. There was no threats, there was no evidence of these things. Also believing things without set evidence. Also Canon Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law, and shall perform all duties of judicial office fairly and impartiality. Judge, I did not get a fair trial. I did not have, was not impartial. The assets were not split fairly. There was not a fair trial. How could you strip parents of their own children for over a year, found due cause or unfitness? I ask that this court, based on Rule 2.3, bias, prejudice, harassment. I believe that I've been harassed by your marshals, by, as you can see here, 1, 2, 3, 4, 5, 6 marshals here. You've also called the Department of Homeland Security, which has also come and harassed me after trial and at the jail, and then also going and having them harass me in a multitude of different reasons for that. So I ask that you recuse yourself on that. Rule 2.4, it's external influences on judicial conduct. I believe that you have a relationship with Ellen Spiegel, which is my opponent for the Assembly District 20 race. I also ask that based on Rule 2.5, competent diligence and cooperation, that you were going through a difficult pregnancy, that you might not have been on the most diligent in following those those canon rules. Ensuring Rule Canon 2.6, ensuring the right to be heard. Judge, I was shut down. I wasn't able to speak on a lot of terms, especially when I was pro se. I also asked under Canon Rule 2.3, responsibility to decide. Judge, over a year and a multitude of please, can I see my children? There was nothing decided. Rule 2.8, decorum, demeanor, and communication with jurors. This wasn't a juror, but it was a part of the defendant yelling and unprofessionalism. Rule 2.9, ex parte communications. I believe that you had ex parte communications with Judge Almasi and told her to throw the book at me. As she admitted in court that you had ex parte communications, and they discussed the contradictory orders. Canon Rule 2.10, judicial statements on pending and impending cases. I believe that you also spoke about my parents' case and the case that I had in the criminal matter. Also, Rule 2.11, disqualification. You should have recused yourself. You and Hardcastle, you guys went to law school with my cousin, my family. You might have prosecuted him. I don't know the exact relationship, but there's something there. Also, Rule 2.12, supervisory duties. I don't believe that you supervised Hardcastle on some of the orders she put in place that stripped me of my parental rights and also my property when I had a refi approved. Another thing, Canon 2.14, disability impairment. A judge having reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or mental, emotional, or physical conduct shall take appropriate action and may include confidential referral. My attorney, Judge George McGlares, came in a drunken state a few times. He ended up committing suicide, and the court did not take that into consideration. There was also the reasonable consideration after Kurt Smith did not appear, and Mark Anderson took his place, which I never met previous counsel. Rule 2.16, cooperation with disciplinary authorities. Canon 3, a judge shall conduct the judge personal and extrajudiciary activities to minimize the risk of conflict with obligations to the judicial office. I believe that you had communications with your husband regarding my case and probably my parents' case, and that there's an association there. Rule 3.1, 3.1, extrajudiciary activities in general. A judge may engage in extrajudicial activities except in prohibited by law, participation in activities that will interfere with the proper performance of the judge's judiciary duties. A participation in activities that will lead to frequent disqualifications of the judge, which I went to a law event where you're on the name badges on those things. There's too much conflict between this, and I believe that there is a complete sense of biasness and impartiality, and as was demonstrated in trial, where I have you deny any visitation or custody on what grounds? Based on a false conviction, a DV that's on appeal. There's no consideration as my children's rights, and they have no right to their father. They haven't seen them in over a year. And I asked, when can I see my children, believing my ex and awarding her 90% of the assets. I could go on with more of these, but I truly ask that you recuse yourself from the complete divorce matter, and that I have a reconsideration went through a different judge and an unbiased, impartial judge, and based on and also that this charge of criminal charge is dismissed, as the counselor approved that letter, and you can bring her in there if you want. It's a waste of judicial time and resources, but if you'd like to, she can come and speak to what the effects are causing on me, my children, and what that letter was there for, and her secretary writing it. So that's why I asked this today, that you recuse yourself, that you disqualify from any future pleadings, and that we seek another judge that's fair and equitable, that can split our property and our children properly, not like Solomon, where when you have to go there, you don't cut the children in half. You don't give the child to cut all ties with their own father, the person that brought them into the world, that has unalienable God-given rights to their children. Judge, you are in a spot of a judicial officer.
They say women are so emotional.
You have taken an oath of certain ethics, and that is being completely usurped in this court, and is extreme despotism. And that's why I also ask that you recuse yourself respectfully. Thank you.
Counsel?
Your Honor, I don't have a copy of the motion or whatever it is that he's reading. I know that he has filed a motion to recuse. It's already been heard. It's been denied. There's a lot of allegations, a lot of stuff in there. That this case has been tried. It's been appealed. The decisions have all been upheld by the Nevada Supreme Court. We are here today to simply appoint him counsel, and I'm not sure why we're going through all this, but I haven't seen a copy of it, and I have a hard time responding, other than I disagree with every allegation he just made.
Mr. Tillman, anything you'd like to add?
Your Honor, in an abundance of caution, I shouldn't.
All right, I just wanted to give you the opportunity. Certainly, Mr. Tillman indicated prior to you arriving, Mr. McDonald, for the 1 o'clock hearing, that he's unable, due to a conflict, to represent you in this matter. And so this matter will be reassigned pursuant to my order, and I'll prepare the order from today, counsel. Another status check for appointment of counsel will be heard by the new judge. Your oral request for reconsideration, for disqualification, and the other requests you've
Dismissal.
made dismissal are denied. They're not properly before the court today. There's no
Can I
motion
submit
filed.
the motion here, Judge, with in regards to my oral argument?
If you'd like to file a motion, I can't take the motion for you. I don't have the ability to file that for you, but you can certainly file it with the appropriate personnel in the courthouse. And counsel, you'll receive notice as soon as I do of the new assignment, and I'll make sure that everybody's noticed, and that judge will take it from here. Thank you.
So, Judge, so that it's denied?
All right. All right.
High quality, guys. High quality.
Alex here with another event on the state versus Michael McDonald. But first, a recap. We did originally intend to appear at the July 8th, 2019 proceedings. However, we didn't get a response from the court on time with respect to our media request. That is most likely because of the 4th of July weekend. Ultimately, defense attorney Craig Mueller didn't make an appearance at that hearing, and it caused the matter to be continued to today. We were present today. We did provide live footage to the public, and the proceedings concluded with another date, this time apparently an evidentiary hearing on the matter, set for July 22nd, 2019 at 10:30 a.m. We do intend to appear at those proceedings and provide the public with another live stream of those proceedings. If anyone is wondering, you can wait until probably the evening of the day that we hold a live stream to review the high quality production, post-production video footage of the proceedings. In fact, most likely within an hour and a half of this video, you will see the proceedings that were held today in high quality on YouTube. The link will be posted in the Our Nevada Judges Facebook, so keep an eye out for that. And of course,
Listen, high quality is a low bar here, so just keep that in mind.
we're looking forward to getting feedback from the public on this issue and any other issues that we cover going forward.
you and told you to tell him this is the second time. This is constant with your attorney. I have a light calendar, but not showing up a second time.
He should be here, sir. I know he had a big calendar today. He had a bunch of cases. Can I call him?
You
And
can
Your
go
Honor,
out.
I have a calendar call in front of Judge Hepburn, so I can't really see it too much.
Well, we're not gonna wait very long. You can go outside and call him. If he's not here in 5 minutes, I'm gonna sanction him.
Yes, sir. I'll call
Right,
him.
go outside. Take 5 minutes.
Because he's a professional. He writes to the judge, hey, can I record this docket? The judge answers, sure. He brings in his professional stuff and he makes professional videos. Our Nevada judges, baby. I'm not doing that. I don't have time. I'm not doing that. I was speaking, Jen, was it with you, about doing that? A whole bunch of judges, especially New York. I had it queued up, but it's a lot of work, so I just haven't gotten there yet. We have enough court right now.
Go back, Mr. McDonald.
335-284, Mr. McDonald, with the defendant present out of custody. Mr. Mueller, why are you late yet again?
I was on vacation when the state filed the motion, and then you set a court hearing on a date I was scheduled for trial, the day back from vacation, and I'm actually missing another trial today down in Henderson to be here today. Now,
You started your trial at 9 a.m.?
10 o'clock, yeah, I'm going to be missing a DUI trial down in Henderson. Now, the reality is the courts have changed very dramatically in the last few months. And
That's
I'm
true.
doing my very best to adjust procedures. Now, I've spent almost my entire practice for the first time ever in district court, which takes a lot more planning and scheduling. Justice court has been removed from the calendar. Justice court is almost basically doesn't exist anymore. So, I've hired new staff, I've put new procedures in place, but where in the hell is the time trying to adjust all the changes you guys are doing that stuff?
Well, that may be true, but that's only an excuse, and you need to be here. The court can't sit and wait every time on your cases, and quite frankly, it's consistently with you.
Yes, sir, you're absolutely right. I don't even disagree.
So,
You've
get
changed,
things together, otherwise you're gonna be sanctioned.
sir. If you can figure out how to be in 54 courtrooms at exactly 9 o'clock, please answer for me.
Then
Because I'm in the
maybe you
process-
have too many cases,
No,
that's
I'm actually
not
in the
my
process.
problem, counsel.
I'm in the process of getting out of criminal law.
Contempt.
So you win.
Contempt.
Okay, I've got to please close out the case.
I think you've been both effective and good here.
Yes, sir.
in
Yes,
front of me,
sir.
but
Yes.
if you have too much, then
You change.
we're constantly waiting on you.
Yeah.
You'll get some
And that's
soon.
not fair to
Soon.
anybody.
Thank
Docket
you,
came
baby.
from 10 and 12 pages of calendar, so I could guarantee that I could come in an hour and a half later and there'd be no problem to 5 cases per calendar. You're right, I can't adjust that fast.
Then speak to the Supreme Court.
All right, anyhow, I'm ready
All
to
right.
argue.
Thank you.
You're right, Judge, I'm frustrated, and it's not with you, but the system has changed very dramatically.
Don't disagree with you, state.
And Your Honor, the state requests that you remand the defendant in this case. He's violated the conditions of his release. When Your Honor
released him to the medium-level electronic monitoring. You were very clear that he was to have no contact with his ex-wife, Candace Ruiz. He's familiar with that being a requirement in family court as well as his municipal court cases involving her. He knows that he's not supposed to be in contact with her. He mailed packages to her home. It doesn't make any difference the fact that they were addressed to the children. He was not supposed to be making any contact with her. Additionally, since I filed my motion, I've been...
This is so, okay, this is not it. This is not the hearing about the form, I think, because this is July of 2019. Maybe it is. I don't know. It doesn't sound like this is the hearing about the form that he forged.
Informed that the defendant has also contacted Candace Ruiz via the internet by leaving comments on a GoFundMe page that she had, which included making references to 1488, which is my understanding is that's a white supremacist statement. Additionally, the defendant was interviewed by Mr. Sanson from Veterans in Politics International. That interview was placed on YouTube. I watched it. In that interview, the defendant admits to having wiretapped Candace Ruiz's phone. There's also history of a GPS monitoring item being found on Candace Ruiz's vehicle that was related to the family court case. That's why I attached some of those documents as exhibits to my motion. In addition, the defendant did a Facebook Live interview in which he acknowledged that he did mail these items to the children, which is a violation of the no contact order. He's not following these conditions.
Number one. Thank you. Number one, I believe my colleague has underscored what I've asserted here is the case. This is the state taking partisan sides in a divorce, nothing more. Mr. McDonald mailed, apparently, assuming everything she says is correct, mailed gifts to a couple of kids he hasn't seen in going on 3 or 4 years now. Now, that's not a violation of the no contact order of any sort. Now, my colleague apparently seems to be offended by exercising his First Amendment rights. Now, there has been no contact. This woman is a divorce case. I don't know if you handle a couple in private practice. They're full of bile and anger and hate, and this one seems to have enlisted the state in his behalf. He's had no contact. I want to have that at your hearing. Show me some evidence. He's had no contact. Apparently, if everything she says is true, he third-party ordered a couple gifts to his kids. That's it. Now, how's that a no contact order violation?
As part of the no contact, my understanding is, and apparently was in the papers that the state provided, that because divorces are, as you said, I think
Vileless.
Okay, and I totally agree with you, but I don't know her name now, but anyway, the other side was the address was supposed to be kept confidential. Is that not the case?
I'm not following you.
That the ex-wife's address was supposed to remain basically secret, which does take place in divorces at times when there is, if you will,
that's all new to me.
threats.
The allegation.
I thought it was in there somewhere that she said that, and therefore his sending the package was basically, I know where you are.
No, sir, I respect, okay, then let's do an evidentiary hearing. Let's get this woman on the stand. Here's your text, your court. This is what you said to him. Movement restrictions of any type, parole, probation, means you're yet to go anywhere near or around the vicinity of your ex. That's in your words. That's to be your ex-wife's house, or soon to be ex, etc. Not to be around her on the strip or casinos. Okay, that's fine. There hasn't been a violation of any sort. Now, these allegations get more phantasmal and more tangential every time we come into court. Now, remember, there's no allegation of violence here. There's no allegation of malicious destruction of property in the underlying case here. This is allegedly recordings of a phone conversation that can't be authenticated. I'm anxious to get this case to trial because it will eventually be dismissed. Having said that, this man's not dangerous, he's not in contact with her, she's got motive to ill will, she apparently has some connections with the district attorney's office or the police department, and has, in the first time in 25 years, found a way to enforce statutes that no one else has enforced against. Now, Your Honor, he isn't violated his state of trouble order, he's gainfully employed, he's doing well, and things seem to be going well. I don't understand what the motivation being to put him in custody. He's on electronic tracking. It's not like you can even, it's not even like we have to debate where he's been. So I don't understand this. I think this actually highlights exactly what I've been asserting, which is the state's been enlisted inside of a divorce.
You didn't address what I asked, and that is, isn't it? I mean, that's what I'd like to know. Was there, again, allegations that this was supposed to, the new address, and I'll ask the state in a second, supposed to be confidential because of whatever's going on in the divorce, and, well,
I'm not a divorce attorney, sir. In fact, if I have to go to divorce court again,
I don't blame you.
I will kill myself.
Let me ask the state.
And yes, Your Honor, that is the state's understanding that this address was supposed to be confidential. That is what Candace Ruiz told me. I'm not sure if the documents I attached as an exhibit to my motion, if they state that, but that's my understanding.
That's where I got it.
Right. So I believe it is in there. I don't recall exactly which document contains that, but that's my understanding of that address.
I don't have, or I didn't certainly look up all the divorce documents, but that's for you guys to do.
Lock him up. Get him psych help because he said that.
So, is it there or not?
As I stand here, sir, I'm not aware of any, as an officer of the court, that any order that he is violating.
Was it the purpose that the address, the whereabouts be kept confidential? I mean, if you want, we can certainly look at the family court records, but that's really both of your jobs. If it's in there and that was the point, and I certainly recall that saying that everything was to remain in place, there is the clear potential, and I have seen this in limited understanding of family court, that when the divorce is extremely, what's the word, anyway, contested, and that the addresses won't be transferred, that only the attorneys in family court will be communicating. And yes, that is the subject that should be brought up in family court as to whether there was a violation, but I did say that all, at least my recollection, that all of the orders or the no contact would be maintained. Have you anybody looked at these orders in family court?
My understanding, the status of the orders, there was a protective order prohibiting contact with Candace Ruiz, that's the ex-wife, and that order has been extended. There's now a hearing set regarding that in September in family court.
Mayor, let's leave it in family court. This is criminal court. There's no threat to custody, safety, the good order, discipline of the community. The man has already spent 6 months in custody as a result of this woman's machinations.
Your Honor, I'm sorry to interrupt. Can I just be heard?
This is your motion, so
yes.
Go ahead.
Okay. And Your Honor, there's been a history of violence against Candace Ruiz by the defendant. It's part of the reason for the no contact. And the defendant has been on the internet, he's been blaming this entire case on Candace Ruiz and has been directing a great deal of vitriol toward her. So the state is concerned with her safety, even though the allegations in this case are forgery, perjury, and things that he filed in family court. That's the connection between family court and the criminal allegations in this case. But
As I think I've said, I have a medical procedure next week, so when do we have a senior?
I know we have one on the 22nd and the 2 weeks, but I'm not sure on the 17th.
Can you ask Cindy when we have a senior?
But the 22nd through August 1st, we have senior.
Well, no, we don't have, we only have them on Monday and Wednesday.
Right.
So if we have one on the 22nd,
Yes. SRs are seniors.
we, unfortunately, because seniors are even busy, all we have is like on the criminal calendar days.
So we need coverage the whole time except for accident.
Okay, so 22nd. All right. I'm going to continue this until the 22nd, at which time I expect both of you to either look up the orders in family court or have certainly, if Mr. Mueller, you want to find out what, I mean, there may be other communication between the attorneys, I assume they're attorneys, in the family court case. I want, and I won't be here, but the judge to have the knowledge as to what the terms were, if this was to remain confidential, and I'll tell you my feeling, if it was to remain confidential and he sent it, it is, and it has been, I've seen it, basically, I know where you live, and that is a violation. So present the evidence, we'll have it at 10:30, make it 10:30, as to what exactly the orders were in family court. So the judge, and I'm not sure who it is, will have an understanding. Generally, I would agree with you, Mr. Mueller, that merely sending gifts to the children certainly isn't under normal circumstances, but as you said, this is a vile divorce. The parties are, well, certainly don't get along in any manner, and it appears from what I have read that the no contact and now a new TPO would tend to show that there was, that this is one of the cases, as I said, that I've seen where it was, you're not supposed to know and will exchange, and actually there was no exchanges towards the more recent history. All right, so the 22nd, 10:30, for the continuation. And this is still scheduled for trial on the 3rd?
The 3rd is a trial date.
Perfect.
Yes.
This case fine.
Okay, anything else?
No, sir.
Right. I'm sorry, but I'm having a medical procedure. I'm out, so I won't be able to do it.
Here we have page 3.
Page 3, Lee.
Kathy Hardcastle.
Right?
Good morning, Judge. How are you?
I'm fine.
Good morning, Your Honor. Karen Mishler on behalf of the state.
Craig Miller, back, Mr. McDonald, Your Honor.
Okay, this would be in case number C335284. This is on the state's motion to remand.
Thank you, Your Honor.
That's correct, Your Honor.
Before we begin, Your Honor, respectfully, I was surprised to see you, it's good to see you, but surprised to see you on the bench. I understand that you actually presided over the underlying family court case, at least in part.
Yes.
I would think it'd be appropriate that we set this over then until Mr. Judge Israel can get back.
For what reason?
Because there's apparently some lawsuit, Mr. McDonald told me about this morning, that you were the defendant in a 1983 action.
Not aware of any lawsuit. And it's previously been held, simply filing of a lawsuit does not constitute a basis for recusal.
Yes, Judge. I think Your Honor, I think you best to Judge Israel would do this.
That motion is denied.
The lawyer or Michael? I'm making a decision, guys, that 3 of you might not like. I am skipping OJ and playing a little extra of this morning because I cannot stop. I will not. I gotta keep going.
Your Honor, may I be heard?
Yes.
And Your Honor, when the defendant Michael McDonald was released on his own recognizance last April by Judge Israel, one of his release conditions was to have no contact with the individual, his ex-wife named Candace Ruiz. Approximately a month ago in June, he then mailed a number of items to his wife's address, although they were addressed to the children. When I filed my motion because this was in violation of the no contact order, I did include some information regarding the family court case. Just I wanted to make clear to Judge Israel that the defendant was no stranger to no contact orders. He understood that no contact meant no contact with the mail, and that he wasn't supposed to be having contact with the children anyway. I've spoken with Candace Ruiz's attorney in family court case, Michelle Hauser, and she was advised that since September of 2017, the defendant wasn't supposed to have contact with his children anyway. Additionally, since I filed my motion, a couple of things have come to the state's attention. Last week, the district attorney's office was holding a CLE. At the conclusion of that CLE, when there were about 3 attorneys from the DA's office still remaining there, the defendant showed up at that location, came over to Nell Christensen, the attorney in charge of CLEs, and stated that he wanted to attend all of our CLEs because they were supposed to be open to the public. He became very argumentative and belligerent and demanded to be attending our CLEs. And when asked who he was, he stated that he worked for Craig Mueller. He then He then grabbed our CLE schedule for the rest of the year and left with it. So we're now having to send investigators to all of our CLEs out of safety concerns. And this brings up an additional concern. If the defendant is actually employed by Craig Mueller, we potentially have a violation of Rule 1.8 of the Nevada Rules of Professional Conduct, which prohibits business relationships between a defendant and between a client and an attorney unless certain criteria are met.
Okay. Counsel?
May I see, is there some evidence I can see or peruse ahead of time? Ms. Christensen write a statement of any sort of? First I've heard of this. I got in last night about 6 o'clock and found out that there's apparently some other allegations. The surprise is utter and complete.
I don't believe a police report was written, but.
Well, okay.
All right. Anything else you wish to present?
Yes, Judge, a few things. Number one, Mr. McDonald's already actually, there apparently was, and I'm not a family court practitioner, there apparently was a family court order of no contact, but the answer was it was clear or not whether he could send presents or not. He sent 2 gifts, that's it. No nasty notes with them, no diagrams, no nothing. So they apparently put the matter back on calendar in 3rd of July for clarification. May I approach?
Okay.
For clarification. And Judge Moss clarified the order on the 3rd.
I don't understand what these gifts have to do with him committing fraud in the court. I mean, he has a whole bunch of crimes. Why are these 2 gifts mixed in with this?
That there was to be no contact by sending no gifts. But previously, before that order was clarified, that wasn't a violation. We've got a trial in about a month and a half. We will be ready to go. Mr. McDonald is not violent nor a threat to the community. He has had no allegations of violence. He has stayed substantively away. I do not believe that even the sending gifts to the child were even, strictly speaking, a technical violation. As other allegations, I just asked my client to give me something, or my colleague to give me something to work with so I can address it.
All right. Anything else?
And Your Honor, the issue is the defendant violated the order of no contact that was issued by Judge Israel. The family court's orders are only relevant just to show that my point is just that he's no stranger to no contact orders and he knows how they work.
Thank you.
With that, I'll submit to the court.
Judge Israel actually, and last time we were here, which is, I specifically actually read Judge Israel's text back to him as what he said. Nothing in Judge Israel's initial order was violated. Said no contact, stay away from it.
Yeah. No contact, nor you cause anyone else to have contact, and not includes the U.S. Postal Service or anyone else. But I don't have to make a determination today as to whether or not there was a violation. He has a contempt hearing coming up. What I do need to look at is, has there been enough of a showing for the court here today to be concerned about his ability to remain out on bond with the electronic monitoring device, and whether or not his actions are starting back with what he was doing that previously led to all of his problems before, of escalating the type of behavior. I would note that back in family court, he constantly violated orders. He would always insist that the order said something else. There was the issue regarding adding a line to an order. I was the one who found that he was a potential danger to his children because he lied to the court about surrendering his weapons after he'd been ordered to surrender his weapons as one of the conditions. And that because of his bizarre behavior, there was a tracking device on his wife's vehicle, engaging in a course of conduct. I found that he was a potential danger to his children. I suspended his visitation with his children until he had been seen by a mental health specialist. He determined whether or not he should be on medication, because what was presented to me in family court was that he refused to take his medication. And he also needed to follow a course of counseling if that was recommended as part of that risk assessment. And then subsequently, there was a search warrant at his house based upon threats, and he was found in that search warrant to have made not only threats against his wife, but threats against the judge that was handling the case, which was not me, but the other judge. And then he had his domestic violence cases pending in municipal court. He was found guilty on one of the cases, sentenced to the maximum in that case, and then he was convicted on the second case, and that case was run consecutive. So he's been in jail for a period of time. He got out in April, I believe it was.
Yes, sir.
And then in June, we're back here again. Then he kind of shows up at the gate downstairs wearing a bulletproof vest. You gotta wonder what's going through his mind, and then he's showing up, according to the allegations here this morning, at the district attorney's CLE, misrepresenting his position as an employee of your office. And so I'm seeing the same type of conduct, and it's an obsession. It's a escalating course.
Your Honor, thank you. You actually enlightened me on a couple of things that I wasn't aware of. May we, I will get Mr. McDonald evaluated and have him followed up. In the time I've dealt with him since the last 4 or 5 months, this is the first substantive allegation that there's a problem. And candidly, it's sending gifts to his kids.
The allegation has been in the past he's bipolar. He supposedly was seeing a therapist. It was adding a line to the letter from the therapist that...
Allegation I'm familiar with, Judge.
Yes.
I wasn't aware that there was an allegation he was bipolar. Having said that, now that my eyes are open to it, I can act upon that as an officer of the court. I'm going to ask that simply you give me an opportunity to address that now that I know there's potential mental health problems.
And I think you can address that. My concern is I think he's starting to create the impression that he is a danger. His escalating behavior as the pressure of a trial coming up starts to impact him. Quite often we see more acting out. I'm not sure that he is capable of controlling himself because he wasn't before. Even after numerous hearings, even after numerous orders. And now we're seeing a continuation of that type of behavior. So based upon that, I am granting the motion. You can have him evaluated by a psychiatrist.
Put your hands behind your back. Put your hands behind your back.
Fred, can you just tell me
Wow.
what he's done?
Dude.
Don't fight.
Stop, come on.
Mike, calm down.
Hands behind your back.
Mike, calm down. Just relax. Deep breath. Mike, take a deep breath.
I got it mentally done. I just want to see my kids. Come on. I've done nothing.
Mike,
Just take it
calm
backwards.
down. Dude, take a deep breath.
Guys, come on. You're gonna really throw me in jail because I missed my kids. Come on. Assistance in 15 Charlie. 15 Charlie. Stop, come on, please, guys. Please, I don't want to. You got it? Please, guys. Let's just hold him. Come on.
Mike, stop fighting with the guys.
I'm gonna take her.
Mike, stop fighting with them. I have to go over there and help them with the cuffs on you. Don't fight with them.
understand? I'm gonna
Don't
tase
fight.
you.
Don't fight with them. Put the handcuffs on. Mike, put the fucking handcuffs on. Or I'll put them on myself.
Great, come on.
I'm on your side, Mike, but you're out of line.
This is ridiculous. Like, there was no order saying I can't see my kids. It's a CLE thing.
Mike,
I just happened to come upon the author. I was talking to a lot of authors. Come on, guys. Start again. I just want to see my kids now. I'm getting prosecuted as an enemy of the state. I just want to... I've done nothing.
All right, here we go.
That he is
Replay.
capable of controlling himself because he wasn't before.
Thank you, Your
Even
Honor.
after numerous hearings, even after numerous orders. And now we're seeing a continuation of that type of behavior. So based upon that, I am granting the motion. You can have them evaluated by a psychiatrist.
Put your hands behind your back.
Thank you, Your Honor.
Put your hands behind your back. Fred, can you please tell my mental health already done? Dude. Possible. Don't fight. Stop. Come on.
Mike, calm down.
Hands behind your back.
Mike, calm down. Just relax. Deep breath. Mike, take a deep breath.
I got it mentally about. I just want to see my kids. Come on. I've done nothing.
Mike,
Just take it backwards.
calm down. Dude, take a deep breath.
Guys, come on. You're gonna really throw me in jail because I missed my kids. Come on. Assistance in 15 Charlie. 15 Charlie. Stop. Come on, please, guys. Please, I don't want to.
You got it?
Please. Yes. Let's just hold him. Come on.
Mike, stop fighting with the guys.
I'm gonna take her.
Mike, stop fighting with them. I have to come over there and help them with cuffs on you. Don't fight with them.
I'm
Don't fight. Don't fight with them. Put the handcuffs on. Mike, put the fucking handcuffs on. Or I'll put them on myself.
Hey, come on.
I'm on your side, Mike, but you're out of line.
This is ridiculous. There was no order saying I can't send my kids to CLE thing.
Mike,
I just happened to come upon the author. I talked to a lot of authors. Come on, guys. Start looking. I just want to see my kids now. I'm getting prosecuted as an enemy of the state. I just want to. I've done nothing.
call for up there.
Wow, that was very good. I got to eat bacon while I watched that. Oh my goodness.
Alex here with another event on the state of Nevada versus Michael McDonald. We left off on July 22nd, 2019, broadcasting live from Department 28 of the 8th Judicial District Court. Senior Judge Kathy Hardcastle presided over the matter because District Judge Ronald Israel was out for a medical procedure. Ms. Hardcastle heard the state's motion to order Mr. McDonald remanded back into custody and granted that motion. The hearing ended with a scuffle between Mr. McDonald and a half dozen deputies. It looks like interest in the case has continued to rise. We have 25,300 watch time minutes on YouTube combined with 3.6 thousand.
Good afternoon. I don't even have the case caption.
Now this is high quality on this channel.
C 335-284, State versus Michael McDonald. Counsel, state your appearance for the record.
Craig Mueller-Bath and Mr. McDonald.
Karen Mishler and Brandon Albright on behalf of the state.
Your Honor, additionally, Mr. John Schaller, a New York attorney, recently passed the Nevada bar, just took his NPR results and is supposed to get him Wednesday or Thursday. He's going to be sitting, with the court's permission, to be sitting with the counsel table with me, keep track of the paperwork. He's going back to get my tie.
Okay. So let's start first with the motion to, I guess, more or less, the motion to exclude the media or the opposition to the admission. Go ahead.
Thank you, Your Honor. I'm not excluding the media.
Well, video.
Respectfully, Judge, I was around actually as a younger lawyer when we had the debates about letting the cameras in the courtroom. The consensus was that they would cause people to behave or to distort the process. That, for the most part, turned out not to be true. And it has been the experience, my experience, that generally press interest in cases is generally good for the system and keeps things going forward. Having said that, I've done about 5 or 6 death penalty cases, a couple of very high-profile political cases. I've had cases that have been in the press all the time. I have never breathed a word of objection about having the press in the courtroom. Unfortunately, at this time, I do have to object. This is not, in fact, the press. This group of people is a clique, social, political clique. They run out of family court. They used to be called Judicial Watch, now they're called our Nevada Judges. This purpose of this exercise is not to enlighten or to inform or to do anything to improve the quality of the court. They are here as a bear baiting exercise to pick at and to make sure they've got a video camera if Michael McDonald loses his temper. And when I said that on Friday or before the last court date, I got a 10:30 a.m. text from a mutual acquaintance, actually forwarding me their video to make sure that I'm not exaggerating this. This is from a real estate agent who I'm casually acquainted with from the Boy Scouts. She actually sent me the link. Would you like to see what they've posted last time regarding these proceedings?
I suppose it's relevant.
May I approach this?
Yes.
I found this morning when I woke up this morning off my Facebook. You can watch their production.
You left off on July 22nd, 2019, broadcasting live from Department 28 of the 8th Division District Court. Senior Judge Kathy Hardcastle presided over the matter because District Judge Ronald Israel was up for amendment procedure. Ms. Hardcastle heard the state's motion to order Mr. McDonald remanded back into custody and granted that motion. During the hearing, there's been scuffle between Mr. McDonald and the opposite deputies. It looks like interest in the case has continued to rise. We have 25,300 watch time minutes on YouTube, combined with 26,000 views. And those are just analytics for YouTube specific to Facebook. There are multiple thousand views on both of the hearings, the ones covered on July 10th, 2019 and July 22nd, 2019. There is a trial in this case in September 3rd, 2019 at 10:30 a.m. We do intend to appear in broadcast. There is a calendar call on August 26th, which we will send a representative to. It may actually occur that on that date, the trial is moved. So keep an eye out for any updates from us on Facebook and YouTube. It is anticipated that this time, District Judge Ronald Israel will be presiding. It looks like Karen Mishra will appear again for the third time, at least as far as we have covered, for the state of Nevada. And Greg Mueller, it appears, will be representing Mr. McDonald. Of course, keep an eye on the Facebook page as these little details may update as well.
Fozzie's always here.
Trial, you'll get to see a submission of evidence, the testimony of witnesses, and the jury themselves will be making a determination as to whether or not Mr. McDonald is guilty or not guilty on the felony counts in this case.
Have you seen this, Nate?
No, Your Honor.
That, hopefully you could hear it. There wasn't,
Yes.
all it was a face with that. Go ahead. You want to see it again? You want to see it? Go ahead.
I think I get the gist, Your Honor.
It's on YouTube as what?
YouTube, Facebook, this isn't, and Your Honor, respectfully, these gentlemen are welcome to stay in the courtroom and report and ask questions. Our defense is not complaining about the press in the courtroom. That's not what the purpose of this is. This is to get sensational videotape. Now, there's not any reason. This is a clique of people that they follow family court, and they are gleefully up here watching Mr. McDonald. This is against the background of this case. You may recall, this is the first time in 30-something year career I've ever seen anybody being charged with falsifying documents in family court, one of which is substantively true, and the other one supposedly on his financial affidavits. So that's it. This is not a man with a criminal record. This is a man who hasn't been allowed to see his kids, and they're going to sit here and poke at him emotionally until he cooks off, and they're going to get it on videotape, and then they're going to gleefully post it. that's not going to add to the proceedings. Now, in a very narrow fact, this issue presented in this case is were the documents fraudulent or forgery, or was there an attempt to forge them or not? Now, I previously moved to dismiss this charge on vindictive prosecution. We've heard, give me a fair day in court, I won't litigate that. But respectfully, Judge, I've never even heard of a family court judge just not taking action themselves and referring it to the state or to the district attorney's office. That's against the extraordinary background of the district attorney's office seeking to intervene into a family court case, which I don't know, I've never even heard of such a thing, or that it's procedurally allowed. Fortunately, Judge Henderson ruled that it was not. Now, this is bear baiting. It is not a solemn trial of a vindication of constitutional rights versus the rights of our community. This is nothing more than poking at a emotionally distraught man on a very narrow theory of liability. And I told my colleagues this. In my career, $80,000 embezzlement case, district attorney's office can't get bothered with it, says it's a civil matter. Future Judge David Barker allows a woman with a $325,000 embezzlement case from her boss to get a gross misdemeanor. Now, those are the kind of responses I've seen traditionally done by the district attorney's office, and I'm standing here defending a man on two theories of liability. One, the affidavit that he turned in that the judge said, or the author said was true, but he added a couple words to it for clarification in a case he's litigating by himself is actually a fraud. And secondarily, that his financial affidavit, when he doesn't have a job, isn't correct. Now, this is vindictive prosecution. It is an unusual, at best, theory of criminal liability. The narrow issues that the state's going to have to prevail on are very narrow, and I do not see that the ends of justice are served by having this camera and turning this into a circus.
Two things before I let the state talk. Did you get the opposition filed by, well, I think it was filed by the individual who runs or owns that company?
I saw that the one was filed on the way to court this morning. I've not had a chance to look at it.
Can you tell them to bring me a copy of it? All right. Tell them to have you seen a copy?
The state has, Your Honor.
Okay. You have extra copies? Are you Mr. Falcone?
Yeah, Mr. Falcone here, I have a copy.
Do you have extra copies to give?
No, I just brought one for myself. You can have it.
I've read it. Now give it to Mr. Mueller. Thank you.
Best interest is not, can you give her a pony?
I'm going to ask the question to make sure we're being accurate with what the document states. To find out what the facts were. agree, the record's a mess.
I make a finding that paternity has been established.
He was a potential danger to his children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
In response, Judge, I'd ask you
Well,
to
take a
inform-
minute, read it.
I see what his arguments are. This isn't a fact finding. And I want to remember, Judge, the state has changed its theory of criminal liability. We did a preliminary hearing on this case where it was deduced that there's about 7.5 million documents filed every year in Clark County Family Court Division. This is the sole prosecution on a fraudulent document. And even then, it's not arguably not even fraudulent. Now, this is not a fact finding. This is a witch hunt. It's not fact finding. Ask Mr. Falcone how many other family court cases he's televised. Ask how many double homicides or police shootings he's come down here and covered. He's not interested in any of that. That's not a fact finding. This is bear baiting for entertainment and spectacle, nothing less.
Well, at least address the issues that are outlined in the, both the Supreme Court rule and the decision. And I will say, because I read the decision, it's not on point for this case. But the issues, sorry, Steve, can you, the case is either on my desk, I think. Can you?
Look on your desk, Judge.
Or Elsie has it, solid versus 8th Judicial District Court. Does the state have a position since he's reading that at all?
No, Your Honor, the state has no position on the allowance of cameras and media in the courtroom in this case.
And the second issue, council approach.
We'll be distracted by the cameras in the courtroom. Now, I make no pretense, and the court clearly is well aware of the emotional state of Mr. McDonald. This is a hideously inflamed divorce proceeding. Now, having said that, if this case becomes an emotional circus, justice will not be done. This is a very narrow theory of liability that the state has to establish. I'm deeply skeptical that they can do so. I believe concentrating on the narrow legal issues presented is what we need to do, and not to get involved with all the who shot Johnny that's gone on with this case. This case I've never seen so many procedural irregularities, let alone seen them all in one case. The district attorney tries to intervene in a family law case. I mean, really? A district court judge down in family court won't enforce their own orders? Really? We're up here trying to jury trial. A jury trial where we're stacked up on murder cases. We're doing a jury trial on whether a document that is concededly correct in substance, if not procedure, is a forgery. And we're up here deciding whether a guy who wasn't working was actually indigent. He doesn't have enough money to hire an attorney, so now he's going to be held accountable for documents on that account. Now, that's 4 procedural irregularities, none of which I've ever seen before. Then we had this circus showing up and wanting to film every aspect of it. I don't believe this is a trial in any sort of proceedings that I've been familiar with. And I've shared with you the other 2 or 3 financial crimes I've done in the last few years. It's inconceivable that the office that couldn't prosecute a $325,000 embezzlement really wants to hang a felony on this guy's, Mr. McDonald's head. Now, I know it's a big organization anymore, and Mr. Left Hand really knows what Mr. Right Hand's doing, but at a certain point, this lapses into vindictive prosecution.
All right, thank you. The case and the Supreme Court rule clearly outline both the, if you will, rights or burdens. Number one is there's a presumption that the courtroom proceedings are open and can be televised. That's exactly what was going on in the Solid case. The findings, if you will, are the impact of coverage upon the right of any party to a fair trial. They, both in that case and in this case, we will be picking a jury, and I don't see that the photography, the video, whatever you say, is going to be impacting the jurors. This and your arguments are well taken that this isn't a high-profile trial, and despite the YouTube or Facebook or whatever it was hits, all that means is that it's salacious, the fight, and that's why people looked at it. That's, of course, all too common, but that is not going to, well, we certainly are hopeful that is not going to happen. We will have a calm and organized trial. B, the impact of coverage upon the right of privacy of any party or witness. Mr., how do you say your name?
Alexander Falcone.
Mr. Falcone, one thing, well, certainly one thing you may or may not have been aware of, you are not allowed to take pictures. The camera will not, better not include any of the jury, and you won't be allowed during jury selection to videotape because they're moving around too much and there's too much going on to preclude you. Jurors are coming and going all the time, and unless you are extremely careful, you would be taking pictures of potential jurors, which is not allowed. Second of all, witnesses, unless they give you specific permission, you're not allowed to take their pictures. You can use the sound, that's fine, but you're not allowed to do that. C, the impact of coverage on the safety and the well-being of the party, witnesses, or jurors. As I said, you're not allowed to take pictures of the jurors, the witnesses, or for that matter, well, I don't know why I forgot, McDonald. C or D, I don't think the likelihood of the coverage distracting participants, given the fact, as I said, this is not a national news coverage. This is one individual putting it on YouTube and hoping to make money off it. I'm sorry?
We're not monetized.
You don't get money from YouTube?
No, to get monetized, YouTube has to create a partnership. That hasn't occurred.
Okay, so in any event, what about Facebook?
Same thing, Facebook's even harder.
You don't get hits off of that?
There are hits, but there's no payment, there's no checks.
All right, in any event, as I said, there's minimal exposure. The adequacy of the physical facilities, we're fully capable of taking care of that. And I don't think any other factor affecting the fair administration of justice. What their motivation is does not concern me. It is, as I said, Mr. Mueller,
It's
that's
for the
a
good of the
very
people.
small contingent. And the fact that people from potentially all over the country look to see a courtroom, whatever you would call it, certainly Mr. McDonald's failure to cuff up, as they say, I don't think those are grounds to exclude coverage. In addition, I want to point out, because quite frankly, my marshal pointed out, we have 65 or 75 jurors coming in, which, along with the parties and other personnel, puts us at the maximum for, as you can see up there, 84 occupancy. So during jury selection, we are maxed out. If you want to sit there, that's fine. You're welcome to sit in. But as far as videotaping during jury selection, it is both impractical and would impede the progression, because people are coming and going, as I said, when they're deselected, if you will, and you would be hard pressed to avoid filming individuals coming and going constantly.
This judge really killed our vibe, didn't he? Wake up, people! Wake up!
Defendant's motion to dismiss for vindictive prosecution. I had a chance to read it. Do you have anything to add, Mr. Mueller?
Yes, I want to make a couple key points. Your Honor, we as lawyers used to be trained initially as apprentices. And frequently, you would sit and work and you would study under a lawyer, and after you'd seen enough cases that you had a feel for things to do, then you'd sit for the bar exam. That fell out of fashion because we created a wildly unevenly trained bar, and we created law schools that then subsequently basically made you read the law anyway. So I'm not quite sure what we gained. Having said that, I bring this up because it underscores several key points about our profession, which is that it is a learned profession. You can live 100 years or 200 years or 1,000 years, and you never see absolutely everything that could happen. You have to draw on your experiences and your observations. I saw you do it today, the last civil hearing. Now, you draw on your experiences. So, I've been doing this 25 years in this courthouse. In fact, there was probably decades went by where I didn't miss a working day in this courthouse. Now, I'm presented with a case that is extraordinary in three key aspects. Number one, Mr. McDonald is in family court. He has zero criminal record, no involvements with the law. His case in criminal and family court is doing fine until his lawyer dies. His lawyer commits suicide a couple days after Mr. McDonald gives him $5,000 to continue the litigation. Then he goes in front of his wife, or his wife's attorney, sees an opportunity. Mr. McDonald does not want to represent it and cannot afford one, and he gets hauled in front of Judge Marquis, where he requests a lawyer to represent himself, and his wife instead gets a restraining order that for the first time ever, Mr. McDonald is not allowed to see his kids. Now this is after a year of no cuts, no problems with Mr. McDonald is flabbergasted. Why can't I see my kids? He complains, and complains loudly about Judge Marquis' decision. In fact, he's so incensed by the way he's treated, he goes down and does exactly what every good citizen does. He files to run for office. He's going to run for state assembly on a campaign of reforming family court, a general common theme in the community. As a result of deciding he's going to run for office, he gets a visit from whom? Not the Secretary of State's office, who's responsible for verifying this stuff. He gets a visit from the Las Vegas Metropolitan Police Department. A police officer decides to verify his residence. Extraordinary. Now we are on ground number one, unheard of. The Metropolitan Police Department getting involved with state politics. Then we go to the second extraordinary thing. The police officer, apparently, all on his own, at least he claims, decides to file a false document. Now this is extraordinary in and of itself because it's alluded, and you've got the preliminary hearing transcript there, or here, I actually put a tab on it for you. You got the preliminary hearing transcript?
No.
This is the first preliminary hearing. This is the one that the state didn't want you to see when they dismissed the case initially. There are 750,000 documents filed every year in Las Vegas Family Justice Court, or District Court, Family Court. 750,000. Do you know how many of those were investigated for being fraudulent? One. And it was done by the Metropolitan Police Department. And then they concluded, and this is extraordinary, we did a preliminary hearing where an expert witness who had to sign off that he wasn't a threat to his kids gave him a report. Now, Mr. McDonald's lost all his money in family court because his lawyer committed suicide, so he's representing himself. So 3 days ahead of the hearing, he goes down and complies with the court order, gets the evaluation, and the doctor forgets to put the line in that says he's not a threat to his kids. So he calls the doctor, says, I need this in the line. She says, oh, get me the report back. He writes the sentence in for the doctor. That's what he does. Shouldn't have done it. Not proper form, but we're lawyers and he's not. Not substantively incorrect. So we do a preliminary hearing, and the doctor gets on the stand. The state calls the doctor, and she says, yeah, this is substantively true. I didn't write that in, McDonald did, but it's substantively true. I do not find him to be a threat to the safety of his kids. So I argue to dismiss the preliminary hearing. How can you have fraud when the statement you've made is in fact true? And I liken it to the fact of me being out of town and having someone sign my name on an urgent letter on something that comes up. It is not fraud if you write something on a document that is substantively true and later adopted by the author. That is the case that they dismissed. Then they refiled this charge to add this pettifogging theory of criminal liability, and then to underscore the nature of this case, they go into Mr. McDonald's family court file and find his financial affidavits. Now, I just been through a divorce. I didn't even look at the damn document. Sorry, I shouldn't swear. I didn't even look at the document. My lawyer said, sign this. I did. Now, we're sitting here, and we're going to do a week-long jury trial on whether Mr. McDonald spent $50 a month on food and whether he was actually working that week or the week that he wasn't working, and if that statement's true, in family court. Now, he's not charged with a misdemeanor filing a false statement. He's not charged with anything that makes any sense. He's charged with numerous major Class B felonies. Now, the soul of vindictive prosecution, it's very clear. Nevada makes it abundantly clear. It's a bright line litmus test. If somebody takes actions or the state takes retribution for lawful actions, it's vindictive prosecution. Now, he's antagonized Judge Marquis. There's absolutely no doubt about that. He has represented himself in family court, and every time he goes to family court, Judge Marquis takes the screw stool, takes his kids away further, and by some mechanism, whether it's through his ex-wife's connections to the Metropolitan Police Department, or whether Judge Marquis picked up the phone, we have an ever-spiraling escalation of pettifogging, never seen before in my life, theory of criminal liability. And all after, make sure you understand this, all after he had the temerity to criticize a public official and go down and run for office. And when that Metropolitan Police Department detective gets on the witness stand, you'll ask him, you investigated any other candidates? You go through anybody else's personal files at home to see if their family correspondence are in order? Now, my colleagues know how strongly I feel, and you can hear how strongly I feel about this case. Let her stand up and in her experience, or her colleagues' experience, or for that matter, anybody in the district attorney's office in the last 30 years can point to one case that is within 1,000 miles of this prosecution, and I'll shut up and we'll do the trial. This is vindictive use of the government authority. This is not, hey, we got a problem with drugs, let's go out and get drug dealers. This isn't a problem we got with drug driving. This is, let's screw Michael McDonald because we don't like him. And that's all this is. This case should not go forward. This case should be summarily.
So he just said that he actually did the forgery. And then he said he shouldn't be charged because nobody else got charged? I don't understand.
Dismissed, and Ms. Mishler should stand up with a straight face and describe any other case that she's handled remotely like this one. Thank you, Your Honor.
State. Your Honor. I find it interesting that defense counsel started by stating that legal decisions must be made through our observations and experiences, which can sometimes be relevant, but obviously, as the court knows, legal decisions are based upon precedent and case law and statutes, not based on defense counsel's personal experience as an attorney, regardless of however long that may have been. So I want to first address procedural irregularities and inappropriateness of the filing of this motion, and then I'll briefly, hopefully briefly, discuss the merits of the motion itself. But largely I addressed that back in November when defense counsel initially filed this same motion. So first of all, this motion is clearly untimely. If this motion that defense counsel filed yesterday is not considered untimely, then the word has ceased to have any meaning at all. Pursuant to 8th Judicial District Court Rule 3.20 in criminal cases, all motions must be served and filed no less than 15 days before the date set for trial. This motion was filed while we were selecting a jury for this trial. It's clearly untimely. There are other rules regarding things like motions in limine and discovery motions, and this motion is clearly not one of those. So this was untimely and should be denied simply on that basis. Further, it's essentially the other procedural irregularity is this motion would have been more accurately titled a motion for reconsideration, because this really is the same motion that was filed by defense counsel on November 5th of 2018. And defense counsel has not explained why after Your Honor denied that motion, he didn't simply file a motion for reconsideration sometime in the past 10 months. I didn't hear any explanation as to why this motion was filed while we were selecting a jury for this trial. Additionally, a number of the arguments made are essentially arguments that would typically be made in a petition for writ of habeas corpus, though obviously the deadline for filing such a writ has long passed. And it really is essentially the exact same motion. You'll notice I compared the motion with the one that was filed on November 5th. The section on the current motion that was filed on September 4th, yesterday, though entirely devoid of legal analysis, the section that says analysis is substantively almost word for word the same as the analysis section of the motion that was filed on November of 2018 by defense counsel. Essentially, that motion was double jeopardy and vindictive prosecution. There's been some editing to remove the double jeopardy argument, but it's essentially the same motion. It's a successive motion and should be denied on that basis. Additionally, so now I find myself in the position of making the exact same arguments that I made when we argued this same motion about 10 months ago. Once again, the defense counsel has established that he completely misapprehends the entire concept of vindictive prosecution. He did not state any case law that is remotely similar to this case and remotely establishes any basis for dismissal of this case, especially while we just selected a jury for trial. The defendant's motion cites Jenkins and it cites DeMarco and doesn't establish how those cases have any remotely similar facts. In the case of Jenkins, the defendant was arrested in a car in which a large amount of marijuana was found, as well as legal aliens. The defendant in that case admitted to law enforcement that she had been transporting illegal aliens. She knew nothing about the drugs in the car. She was then prosecuted on drug charges. She took the stand in her defense and testified that she knew nothing about the drugs in the car, and all she thought she was doing was transporting illegal aliens across the border. Then while the jury was deliberating in that case, then for the first time the state filed charges charging her with human trafficking of illegal aliens for the first time, essentially covering their bases and essentially penalizing the defendant for taking the stand in her own defense, which is a constitutional right. Nothing of that kind has occurred here. And defense counsel's entire argument is based on, at least in the motion, is based on the activities of law enforcement, stating that the entire reason for this prosecution was simply the fact that he was running for office, which is simply not true. Additionally, that's not an argument that's even related to the case law regarding vindictiveness. The state doesn't have to establish the reason for the prosecution. And this court doesn't actually have jurisdiction to evaluate the behavior of the police unless there's been an issue raised regarding the Fourth or Fifth Amendment, and that's not what's going on here. In none of the cases regarding vindictiveness, either prosecutorial vindictiveness or judicial vindictiveness, in none of those cases did the court ever hold that the initiation of the initial prosecution itself was improper. I reviewed all of this case law. In none of these cases, the U.S. Supreme Court or the Ninth Circuit or any of the other federal courts, none of them ever held that the state should not have been prosecuting this defendant at all. It is held there was some sort of procedural irregularity in which the defendant was penalized for exercising her right to testify at trial, or for exercising an appellate right, or for exercising the right to a change in venue, which exists in the federal system, something along those lines. At none of these cases did the court conclude, oh, well, this person should not have been prosecuted. And I think the argument needs to be put to rest that the fact that this is somehow an unusual case means that this case must be dismissed. I didn't hear defense counsel cite one case that stated that the state must establish that a defendant has been previously prosecuted for similar conduct in order for a case to proceed. Criminals every day are thinking of new ways to commit crimes. Additionally, there is nothing in the forgery or perjury statutes that requires that essentially means that a defendant cannot be prosecuted for those crimes if they occur in family court. There's no special inoculation for the fact that something occurs in family court. A person can still commit crimes by filing a forged document. And I find it strange that defense counsel seems so confident that nothing of this nature has been prosecuted before. I've been on the fraud unit at the DA's office a mere 2 years, and without much effort, I can think of two similar cases. One, the case involving April Parks and numerous other defendants, which was based upon numerous fraud as well as theft involving guardianship cases. And as we all know, guardianship cases are part of family court. And all of those defendants have been, all of those cases except for one of the defendants, those have been closed. The defendants took guilty pleas. April Parks is in prison now for actions she took in relation to family court. And the sole remaining defendant is set to go to trial next week in front of Judge Shara Jones. Additionally, James Vega, I myself recently charged an individual with numerous crimes and had a criminal complaint filed based on what was initially being investigated in this case. There's a gross misdemeanor charge in the Nevada statutes called false candidacy, essentially called false residence for candidacy. There are certain documents that a candidate must file when they run for office, and they must list their address and establish that they live in the appropriate district for which they're seeking office. James Vega is currently charged with violating that crime as well as forgery and other crimes stemming from that incident. But again, I hope Your Honor doesn't take the fact that I pointed that out as somehow capitulating that we have to establish that the state has prosecuted similar crimes like this in the past. That's simply not a requirement. I didn't hear any case law being cited that supports that idea. Quite frankly, this is a frivolous motion. It's virtually identical to a motion that was filed by defense counsel approximately 10 months ago that Your Honor denied, and now it's being refiled. This is the most untimely motion I think I've ever seen. And while I may not have practiced as long as defense counsel, I've been barred about 5 years. I've never seen something this untimely, and there's no reason for it. There's absolutely no reason that the defense counsel couldn't have filed a motion for reconsideration 9 or 10 months ago. And yesterday, when I brought this up, the fact that the motion was successive, defense counsel stated, well, the state has changed its theory of liability since I filed that motion, which one is not true, and defense counsel knows that, because we're proceeding off the original indictment that was filed in October, prior to the defense counsel filing that motion. Additionally, nothing in the motion or in his argument deals with the state's theory of liability in the first place. So, defense counsel, quite frankly, is violating the rules of professional conduct. I mean, he's in violation of 3.1 because 3.1 requires only the bringing of meritorious claims. This is a frivolous motion, and the rule states the lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so. There is no basis in law or fact for bringing this motion, and defense counsel's personal experience practicing in this jurisdiction is not a basis for this motion. Additionally, he's violating Rule 3.3, which requires candor to the tribunal. He basically lied to Your Honor yesterday. Further, Rule 7.60 of the 8th Judicial District Court states that sanctions may be imposed when counsel presents to the court a motion which is obviously frivolous, unnecessary, or unwarranted. This motion is all of those things, and I request that Your Honor impose sanctions against defense counsel. Thank you.
My colleague just failed miserably. She didn't mention one case where a pro per litigant was pulled into court for a false filing.
All right, counsel, let's address what I want to know, and that is untimeliness, and this is a motion for reconsideration.
Right, Judge.
You can call it what you want, but it's 6 months after the original. It's untimely.
The original, respectfully, my colleague doesn't remember the procedural history of this. I filed a motion to dismiss on procedural history because they went forward on a factually correct filing. They didn't dismiss and brought 2 additional theories of liability that his financial disclosures weren't accurate. Now, she cannot, has not, and will not be able to stand up and tell you that any other pro per litigant has ever been held to account on felonies. She mentions 2 fraud and theft cases. That's not this case. Now, this is a man who ran for office, and after he filed for office, he was charged with a crime. I have a moral and ethical obligation to make every opportunity for the judge to do, the court to do the right thing here. Now, this is not anywhere near a civil case. This is a criminal case. He is wrapped with the Constitution and constitutional rights. Now, this is retribution for criticizing a judge and for running for office. Pure and simple. This is political, vindictive prosecution. It's not selective enforcement. She didn't stand up here and said, yeah, let me tell you about the other guy whose lawyer killed himself and was prosecuted for filing false documents. That didn't happen. All these documents here are pro se litigation documents. Now, I see an enormous difference here between what she's talking about and what she's trying to do. Now, 750,000 documents get filed a year down there. Who gets prosecuted? One guy. One guy. And was a fraud detective? No, it was a Metro detective. Now, Your Honor, this is vindictive prosecution through and through. And yes, I have a moral obligation and legal obligation to make sure that the record is correct here and you understand exactly what's happening. Now, this is not correct. It's appropriate, and under criminal law, I can stand up at any time appropriate with the quorum of the court and make a record of what needs to be done. I've drawn the court's attention to the law. It's in the motion. I've drawn the court's attention to the fact. I've drawn the court's attention to the extraordinary procedural abnormalities here. I've also drawn, and she's underscored, the fact that there's no other case anywhere in the system like this one. And I don't understand how we don't reach the simple conclusion that this is vindictive prosecution.
All right, thank you. I'm denying your motion on numerous grounds. First of all, it's extremely untimely. There is nothing that has changed in the last let's say, 2 months that would have precluded you from filing this motion on a timely basis. To file it in the midst of selecting a jury, a substantially similar grounds to a prior motion. You're right, it's not exactly the same. I grant you that. But this could have been filed 2 months ago easily, if not before that, or certainly 30 days ago. Nothing has changed here that would have prevented you from filing this in a timely manner. Second of all, I do consider it, even though it isn't identical, it is substantially similar to the prior motion, and therefore it should have been a timely motion for reconsideration. The arguments made are the same arguments that were made back then regarding the fact that the defendant was the only one who's been prosecuted under these similar circumstances. But again, the next grounds for denying it, the fact that no cases are identical or this hasn't been done doesn't mean it shouldn't be done. Your argument, which would seem to be that people do fraudulent things in family court all the time and they're for some reason picking on my client, and quite frankly that is not grounds. They should all be following the law. And if the state in this case, and I use the, not this particular case, but if the state decides they need to enforce, I hate to use an old word, shenanigans that do take place every day, allegedly take place every day in family court, then that is appropriate, both for basically showing that it shouldn't and can't be done if in fact it is illegal, and if in fact in this case Mr. McDonald did and carried out what is alleged, then he violated the law. The cases you cited, the only 2 cases, are nowhere near what we have here, and you argue that this is somehow judicially driven by the family court judge. Not, again, that is not your allegation in the written pleadings that this was done because he ran for office. So your statements today belie your claim regarding Jenkins' case that this was done because he ran for office. Now you said it's because he made allegations and by the way, I think both parties seem to think I have a knowledge of all the facts in the family court case, which I do not. Judge Hardcastle was more informed because apparently she was part of proceedings down in or over in family court. But in any event, as far as the actual grounds, if you will, under the federal cases, they don't apply here. In addition, as the last comment,
I find no good cause for the delay in filing this. As I said previously, there was plenty of time in the last, we've met several times on several issues in the last couple months prior to yesterday. And so there's absolutely no good cause for the extensive delay. I'm not going to order sanctions. I think they're reserved for the most egregious of actions. Although this is delayed and it has cost us a half hour or 20 minutes before bringing the jury in, as I said, I'm not going to award sanctions. That's it. The state will have to prepare an order on that.
Yes, Your Honor.
Anything else before, and by the way, we're going to take a couple minute break since I've been gone. We've been here for well over an hour. You weren't, but we have. And then we'll bring him in unless there's anything else. State.
Not from the state, Your Honor.
Defense.
No, Your Honor.
Okay. We'll take about 2 or 3 minutes.
This is it. I have to stop here. I have to. I gotta go to work soon. I gotta stop. I don't want to, but we've been at it for 3 hours, so we did good today. Man, so, you know, it's way less than 24 hours. We'll be at it again. Maybe I'll start a little early tomorrow so we can get a chunk in. Maybe. We'll see. If I work a double, so me waking up early is probably won't happen. Oh man, guys, thank you so much for today. Today was awesome. This was so good. All right. Fozzie, call me really early tomorrow and wake me up. He said, I can't. I'll be asleep. See you all soon. I hope you have a great Saturday. I hope the snow doesn't get you. Bye, guys.
Got these lights that goes digital dreams through the screen. Her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always first grade.